I'm sorry, was that a yes? That's a yes, got it. All right, ladies and gentlemen, good morning and welcome to the February Valentine's Day Eve edition of the Tennessee Real Estate Commission. We're glad you're here. Ms. Maxwell, would you call the roll, please?
Yes, you want me to do the public disclaimer and then
I prefer you do that first, as a matter of
yes.
fact. Thank you for pointing that out.
Yes. Notice of the February 13th, 2019 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since September 18th, 2018. Additionally, this month's agenda has been posted on the website since Friday, February 8th, 2019. Commissioner Jeff Diaz.
Present.
Commissioner Rick Douglas. Commissioner Marcia Franks.
Here.
Commissioner Diane Hills.
Here.
Commissioner Austin McMullen. Commissioner Fontaine Taylor.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
Here.
You have a quorum.
Thank you, ma'am. At this time, I'm going to ask Commissioner Bobby Wood to lead us in a prayer, and then if you'll stand following that, he'll also lead us in the pledge to the flag. Mr. Wood.
Okay. Bow with me. Most gracious Heavenly Father, we just thank you so much for this day. We just thank you for the opportunity to be here, and just thank you for the safe travel that many have already experienced, and just ask you to be with us today as we conduct your work, and just allow us to be able to do this just with our ultimate goal of doing what is best for our state, and just ask you to be with us and protect us as we head home later today. That's your name. Amen.
Amen. Flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Bobby.
All right. Thank you, Mr. Wood. We've got to approve today's agenda. You all received that by email. Is there a motion?
Move to approve.
Second.
I have a motion by Ms. Frank, second by Mr. Diaz, that the agenda be adopted as presented. Ms. Taylor.
Yes, I'd like to add to talk about the
Do you have a preference where we put that? We can put that under the Executive Director's report.
Is it your, yeah, well, that's fine with me, yes.
Okay, let's just put that there then.
So that'd be call center, maybe?
Well, yeah. I think that the gist of the topic is that you and other commissioners are receiving calls from licensees saying they're having a difficult time making contact. That.
Yes, that's a me.
Okay, I got it. That's what it's going to be. Other additions or deletions to the agenda? If not, are you ready to vote to approve the agenda? Since you are, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next up is to approve the minutes of last month's meeting.
Motion to approve.
Motion by Mr. Diaz, seconded by Ms. Hills, that those minutes be approved as presented. Discussion?
I'll be recusing myself since I wasn't here.
All right. Are you ready to vote? Let's do it. Those in favor of approving the minutes, vote aye.
Aye.
Those opposed, no. That motion passes on a 5 aye, 1 abstain vote. Ms. Franks abstains. For a good reason. She was frankly representing this commission at an Arello meeting, and we'll hear a report on that later in today's meeting. All right. I'm guessing you're Timothy Carter. All right. You got a broker coming, right? When he gets here, we'll get to you, okay? We're not going to skip you. All right. We're just trying to be efficient. Mr. White, Education Director's report. Good to see you this morning.
Good morning, Mr. Chairman, members of the Commission. We have a sunshiny day, so that's good.
And you're also a weatherman, apparently, too.
Yes. Good morning again. I'd call your attention to the February agenda, education agenda, and I want to report that I've reviewed all the new providers, existing providers, the instructors, and the courses for this month's agenda. And I submit to you for your approval F1 through F29.
Move to approve.
To be clear, we're talking about the courses at this point, right?
Yes, sir.
Okay, the motion by Ms. Frank, seconded by Mr. Diaz, is to approve the courses presented to us today by our Education Director. Discussion on any particular course?
Yes.
Ms. Hills, which one you want to pull out?
F6.
F6?
Uh-huh.
All right, let's vote on F1 through F29 with the exception of F6. Any other courses before we vote that you'd like to pull out to discuss? All right, if not, let's vote. Those in favor of approving F1 through F29 with the exception of F6, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. F6, Ms. Hills.
The only thing that caught my attention, and since it is a 30-hour class, it says, and maybe it's just a sort of what they're using to advertise, but it's 30 hours online self-paced course. Do the materials, are the materials strong? I mean, the self-pace is what just jumped out at me. I mean, is there a time frame that you just can take 30 hours or?
Yeah, I think they just word that to be user-friendly for those folks as a marketing tool, if you will. But
Okay.
It's still the 30-hour course. They have to complete all of that, and it's still the same materials but it's
Okay.
just the way in that I think they're trying to market it.
Okay, I thought possibly, but I thought 30 hours. So, motion to approve F6.
Second.
Motion by Ms. Hills, seconded by Ms. Frank. Ms. Franks, that course F6 be approved as recommended by our Education Director. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now on to instructors, Mr. White.
Mr. Chairman, members of the commission, I submit to you the instructors that need approval for today. There are 4, and they're also on your iPads for review.
All right, is there a motion?
Move to approve.
Motion by Ms. Franks,
Second.
seconded by Ms. Hills, that the Education Director's report be accepted and F1 through F6. Is it F1 through F6? No, the 4 instructors recommended, let's just go that,
Yeah.
be approved.
I have a question.
All right, Ms. Hills.
So, on the first instructor, I was looking at achievements and qualifications. So, what's the name of the company? Is the name of the company that team name?
The mission team.
So is there a
Mission
name of a company? 'Cause
That's the only one that was associated with this.
so that concerns me.
Okay.
that an instructor is not. So then,
So if
when
we
I-
were to look at their license with the state, does it say the mission team?
Her license is individual license, and we looked this up. I think we talked about that last night. That's Ms.
And-
Bangman.
They don't have to necessarily be licensed, do they?
but they're saying they're licensed in Knoxville for 15 years.
I may have a point of order on that. I think that she has been licensed for 15 years total. She held a license in Virginia, I believe back in 2008 or 9 is when she first got it. And her husband have moved, or they're in Knoxville now, and their website and their company's called the Mission Team. She's not holding herself out other than being, as part of this team, if you will, that she is the speaker and the instructor, and that she has instructed before, and she wants to gain that registration in Tennessee.
She is actually with Quality Homes Network, LLC, Century 21 Legacy.
What bothers you about this?
Well, it bothers me if we're approving an instructor and the material that's sent in for approval is not given the company name. It's just given a team name. That bothers me.
Mr. Woods, does that bother you as well?
Yes, and I had the exact same problem with somebody we approved last year, and we approved them. And that they sent everything in as their team name and didn't bother sending in their company, and they were advertising themselves as a team. I mean, then I got the same problem. If they don't comply by the rules now they're going to allow them to instruct people, and I don't know that they're going to instruct them properly.
On their Facebook site, it has Century 21 on it, the mission team Knoxville, and it's she and her husband.
That's what I understood to be.
So when did she say when she was licensed in the state of Tennessee? So you said you said that she's been a realtor licensee for 15
But I
years.
actually think she got her license, and we looked it up and
I think
found
it could be best for Ross to go back and review what she submitted and maybe
Okay.
represent her later today
Later. That'd be
to
fine.
see if it was an issue of what she submitted or if it's an issue of what we redacted from what she submitted.
Thank you. And I have one more question.
So, just so we're clear here, is it your desire, and feel free to make a motion, that we defer action on this until we get more information?
Exactly that. Just
Mr. Wood seconds that
the
motion.
chairman.
And that may happen as early as today.
Good. Thank you.
Okay? Without objection, we'll proceed. Ms. Hills.
And the last instructor, Holiday, Eldon Holiday. So it's to instruct. He's a home inspector, and to instruct. It's just, it seems like he's been in this industry for a short amount of time, since 2017, residential builder in Mississippi since 2019. So it just, so I guess if he's had enough education, he qualifies to teach. But that's my only concern about that. If anybody else has any concern.
I had the exact same concern. And so basically he's been doing this 1 year.
Yes.
And so did we not have
Yes.
any kind of requirement on a minimum that you've done something before you can be considered an expert and be able to teach about it?
In reviewing his documents, he has several certifications in the Southern Building Code and so forth. So I don't doubt that the young man has his credentials, but there's nothing really, no impediment that I know of that would hold him up from being an instructor either for this particular course. So it is up to the commission to decide, what you want to do with it. But I think that he's in good shape, certainly, to submit an application for approval. And he does have the qualifications as a home inspector, and he is licensed through the Commerce and Insurance, home inspection section.
Does he reside in Mississippi?
No, he resides here, is what I understand. Both Mississippi and Tennessee.
Just so I'm clear, we're asked to approve 4 instructors today, correct? We've deferred action on one of those. We're discussing the second one. It might help this chair keep his act straight and together if somebody would make a motion to approve the 2 that are not.
Can I say
Controversy.
this about the first one? The Laura Fangman, she was licensed in the state of Tennessee July 9th, 2018. I'll just check verify.
Do you mean to make a motion? I want to make a motion that we approve of instructors number 2 and number 3 in our group.
Second.
Okay, I have a motion by Mr. Wood, seconded by Ms. Hills, that instructors identified as number 2 and number 3 on the list of recommendations from the Education Director be approved. Discussion. Excuse me. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Okay, Ms. Hills, what do you want to do with number 4, the home inspector?
Bobby, I thought
Mr.
you were
Wood?
going to.
I guess I'm just concerned. Do we not have any kind of minimum that you have to have done something, or is it just based upon your education? I mean, a person can go and get certifications.
Of course.
That's a home inspector, and I don't really know what you may have to do a certain number of inspections or something. I get that's just my concern, Ross. I mean, if you're confident that this person knows what they're talking about, that they're able to instruct people, I mean, based upon what they're sending in.
Yes.
Okay.
But I have background from the State Fire Marshal's office and from home inspections and so forth, and I helped to write the rules on that back in the day. So I understand a little bit about what they do, but I can't make a decision about whether or not you all think that it's proper. I think, as I submit it, I think he's in good shape. I don't have anything legally that I could hold him back on that would give me pause. So I think about factually, he does have his credentials.
So not being a licensee, right? He's not a licensee.
No.
Right.
Okay. So
That's
he's not taken the educator class or anything like that either. Then.
Taking the manual so far. So that's the only thing that's, that we have to judge at this point.
And I think we're coming up with this nearly every month as to, what the requirements are. I think probably this person's met the requirements. I think for this commission, though, we may need to have some sort of discussion about, do we want to raise that level at some point?
Oh, would you look at page 105, and it's Rule 1260, 05.05. Oh, excuse me, .04. I was looking at the top of the page. So 1260, 05.04. And I guess the D refers to licensees, and I've just turned to it. I haven't had that much of a moment to look at it. But F, does F not refer to in the field of what they would teach?
Well, F says in the field in which a degree or other recognized designation is commonly awarded. So for home inspectors, there really isn't a degree for that, but he does have the other recognized designation, which he is a home inspector's license, C.
There is a construction degree, though.
There is, but that's not necessarily, I wouldn't say it's a degree program tailored specifically to home inspectors.
But he doesn't have 5 years experience in the field either.
Is he a dual licensee? Does he have
Doesn't have a license.
Does he have a license in Mississippi?
He does, as far as the home inspection.
Do we know how long? Can we defer this one as well until later in the
Motion
meeting
to
so
defer.
we can get some more information?
All right.
We've already deferred that.
Not this one. This so the motion offered by Ms. Hills and seconded by Mr. Wood will defer action on approval of this applicant until we get a little bit more information, which it could occur as soon as today. Let's discuss that. Ms. Taylor. You okay?
No, I wasn't discussing
Okay.
that. What I was going
Is
to
there any
ask.
objection to that being deferred? Okay, without objection, then that's what will happen. Now, Ms. Taylor.
I was just going to ask, when these educators send you their information, do they send a sample course or anything for you to look at of what they're going to teach? Or, I mean, I know the courses come later, but when they're applying to be certified as a teacher, what, do they just send you a list of their credentials and nothing else?
Essentially, their credentials, resume, copy of the manual that they have read, and an affidavit, and their fee, and their application. Not a lot more is required in our rules and law for the instructor registration. But typically, they come in with a course because that's the course that they're teaching. However, not always, but typically they're listed on the course application as well as on their individual instructor application. So you can see the course that they're teaching, but it's the provider that's submitting the course, and then they are the instructor for the course.
So, Ms. Matlock, would it take a rule change for us to increase the minimum standards?
Yes.
I think it's something we all need to think about.
All right, Mr. White, you've got a little work left to do today. You got to flesh out these two applicants and get back to us if you can get that done.
Mr. Chairman,
Now,
thank
on
you.
another topic, and this is just a personal thing with me,
Well,
when one of your applicants used the term, this person has been a licensed realtor since a particular date, I could care less about the realtor part. Okay, a licensee is fine. I don't care if they belong to the trade association or not. Just personal. Okay, thank you. All right. Anything else? We also have you to stand by on this printed correspondence course discussion today. And I don't know if there's any desire on the commission to move that up or just keep it where it is. And I know we've got two informal appearances we need to handle. Just something to think about. Because if we're going to wait and do it later this afternoon, then we'll send Mr. White on to flesh out those two applicants if you're instead in the mood to.
I included a little synopsis in my report that I was going to present to you guys as well, if you want to.
Okay, we'll just wait then.
Yeah.
We'll wait. Okay. When you have more information for us, let us know, and we'll break in and handle it. Okay. All right, Mr. Carter. I didn't know you were bringing a champion with you. I got it. Will you two come forward? Our law director is going to ask you to tell the truth, the whole truth, and nothing but the whole truth. All right. Gentlemen, this is how it's going to work. Our executive director, Ms. Maxwell, is going to give us a little history on why you guys are here. Once she's through with that, we're going to turn the floor over to you, Mr. Carter. You tell us anything you want to tell us about the event that caused you to have to be here, anything that's happened since then, anything you'd like for us to know about you. Commission then will ask you questions if they so choose, and then we'll go to Mr. Champion and ask him why in the world he'd like to be associated with you or vice versa, okay? And we'll get to ask him questions as well, and then we'll take a vote. Okay? Ms. Matlock.
Okay, before you have applicant Timothy Carter. Mr. Carter has taken the real estate affiliate broker exam. His principal broker, Stephen Champion, was first licensed as a broker in April 24th of 1997. This should say no disciplinary actions. There is one pending. His firm is Greater Downtown Realty, LLC, doing business as Keller Williams Realty. An applicant's summary of the criminal / disciplinary sanction is felony theft over $1,000 from February of 2011. And the disposition of the felony charge has been satisfied, and his statement and the broker's statement can be found on your iPad.
Thank you, Caitlin. Mr. Carter, we also have some documents that were provided to us. We have your narrative of what happened. And I read that and I went, God dang. So how about giving us your take on what happened and what's been going on since?
Sure. I would be remiss in saying that there's some things that aren't in that narrative that I think you probably should know.
Got the floor as long as you need it.
Because they're relevant to me. They may not be relevant to the charge, but they're relevant to me. And so I moved to West Tennessee as a real estate agent through a divorce and in 2005. And so I started with RE/MAX then, and I was there for a few years, and when the economy kind of turned south, I started to struggle. I was working mostly with buyers, and at the same time, I had gained full custody of my daughter through a tumultuous situation, and my mother also had actually tried to commit suicide. So during those situations, I started making decisions to cope in poor ways. I was drinking a lot, and I was doing cocaine. And I was spending a lot of time at the office late at night, and during one of those episodes when I was there at the office, I was outside, and as you know in the story, I found a ring. We had a strip plaza that we worked in, and so there was a jewelry store there. And so I knew the guy that ran the jewelry store, so I asked him if it was a customer's, and he hadn't had any information. So I held on to the ring for, I think it was about a month, but I'm not sure exactly. And so after that time, because I was struggling, I decided I would pawn the ring. And after pawning the ring, it was probably another month or so. I got a phone call from the police to want to meet me at my house, and they arrested me for the ring, which I found out was stolen from my office, along with a gun and a necklace. So during that time, obviously I bonded out of jail and couldn't practice real estate with RE/MAX, and I tried to move my license to another location, which I was able to, but then I think because of the pending felony charge, they felt like it was too much of a burden for them, and so I was sort of in limbo. That limbo lasted for, well, until around December of 2011. And in December of 2011, by that time, I had moved a guy into my house. He was renting a room. I had subsequently lost custody back to my ex-wife at that time for my daughter, and my mother was trying to recuperate back in Chattanooga. So I went to court and accepted a plea bargain. It was a judicial diversion plea bargain for the charge because I definitely had the ring, and so I felt like it was a very difficult case for me to win. That plea bargain was for a 3-year probation, and unfortunately the guy that I moved into my house was cooking meth. And so I accepted a plea bargain on December the 27th of 2011, and I was due to meet my probation officer at the beginning of January. And I think it was January 7th, if my memory serves me correctly. But January 5th, the police came to my house looking for my tenant. Didn't have a formal agreement with the guy, but that was the situation. He actually was locked up in jail for stealing. And so I knew I was on probation, and I knew he'd been cooking meth, and I couldn't get him out of the house because he was in jail. So I was hiding. My fiance at the time, she opened the door. They subsequently burst into the house, and they got us. They surrounded the house, and then through, I guess, a search, they found several of his, I think they call them shake and bake meth labs. So I was rearrested and on a manufacturing charge and put into jail. And so now I'm held on a manufacturing charge, but now I'm also on a probation hold. So we went to court on the manufacturing charge, and it was dismissed on an illegal search. The circumstances of that have been expunged, but I then had to go to a probation hearing because I was in the presence of drug activity, and so they violated my probation and sentenced me to prison. I served 14 months in prison before I made parole, and then since that time, I lived in West Tennessee. I got married to that fiance. I was in West Tennessee on parole for 18 months, and at the end of that 18 months, our marriage didn't really work out. We were two different people, and I moved back to Chattanooga. While I was in prison, I wasn't raised in the church, and while I was in prison, I happened to get saved. And so after moving back to Chattanooga, I started doing prison ministry. And so through the prison ministry, it's something that's been able to stabilize me and keep me in the right path. I've always wanted to come back into real estate, but I felt like I needed to have enough experience and trustworthiness in the positions that I've held and the things that I've done before I came to this situation here.
Thank you. Commissioners, questions? Mr. Carter.
I had a question in reading this. It said that you were, I guess, convicted of taking this handgun and necklace, but did they ever find the handgun and necklace? I mean, or did you take that, I guess is my question.
No, sir. Yeah, when they found the ring that I had pawned, there was evidently a charge or a theft charge or a missing item report that all three of them were in it, so that's why I got charged with all of it.
And also,
In the according to my attorney at the time, it was something to the effect of, if you're in possession of one, then they can charge you with all of it. So I didn't know how that happened, but that's what happened.
and I did just think it was odd. I mean, if a real estate office, if somebody had felt that, say, a ring had gone missing there, I can't believe they weren't asking their agents, hey, have y'all found a ring or something that you maybe wouldn't have heard that or something in your office?
That was actually part of what was, I guess, such a shock to me, because I'd been there for 5 years and I was there every day, so I never heard anything of it. And so it was a traumatic situation when it happened to me, but there weren't a lot of words exchanged at that point in time after the arrest.
Diane.
And you were first licensed?
In Chattanooga in 2004.
4.
Yes.
Okay. And this was happening in 10 and 11, correct?
See, really, it was the beginning of 2011, and then went to jail in 2012.
Okay.
Prison, I should say.
Did you retire your license at that time, or?
No, my license expired while I was incarcerated.
Okay. And so you've retested?
Correct. Re-educated, retested, yes.
I would just like to say this. We probably got. I appreciate that you included everything in this, probably the lengthiest information that we've ever gotten from anyone, and so I do appreciate that.
Carter. Commission reserves the right to come back to you again. Mr. Champion, first of all, the story that Mr. Carter just told,
Yes, sir.
had you heard it before?
Yes, I have.
So there's nothing new in the story today.
No, there's not, and we've met a couple of times and had pretty lengthy interviews. And in our last meeting, before I said I would come here, was, Tim, if you tell the whole truth, I'll stand by you, because I believe that's in your past. If you shade the truth, I'm not going to Nashville.
We've had a case before where a broker heard new information at the time the applicant appeared before us, and that broker basically said, I'm not going to sponsor you, and
Got up
she
and left.
walked out.
Yeah.
So with that background, tell us what caused you to think this is a good guy to take under your wing.
Well, Tim and I worked together years ago when he was newly licensed, so we had a history there. I don't think I had such a history that I can absolutely vouch for everything Tim was doing during those days even, but his behavior was professional. He was very well liked amongst all of his peers, colleagues, customers, clients. All that went really, really well. So everything I did know was very, very positive. The more we talked after this incident, is just, does the story make sense? And I struggled with a couple aspects. You found the ring, did you? Right? I mean, those were, and I voiced some of that as well and kind of came back to some of those things. I talked to some people that were around him at the time of the incident, and I believe his story.
Commissioners, any questions for Mr. Champion?
I would like to say that Mr. Champion was actually my instructor in the Train the Trainer class. I have full faith in his in the faith that he has in this gentleman. I know he's professional enough that he wouldn't be taking someone without really keeping a close eye on him. And so, Steve, that's what we are going to be dependent on you to do, is to just give him an extra eye, keep an eye on him. And then for you need to really understand that Mr. Champion is putting his license on the line for you, because if you get in any trouble, he's probably going to be in maybe worse trouble than you. So just always remember that, and always uphold this faith that he has in you.
Other questions or comments? So for Bobby, go ahead.
Go with yours.
So to both of you guys, so your history, your past is your past, and it involved a charge of theft. Now, I expect at some point people will find out, especially if you're in the process of listing a house and somebody says, "Hey, you stole before. Why should I be concerned about that?" Have you guys talked about how you address an issue like that? I mean, you can't do anything about your past. How do you handle that type of objection?
You know, I mean, I don't know, I guess, until I get into a situation, depending upon the type of rapport that I have with a potential client. I think that I would try to navigate through the situation as transparent as possible so that they can make the best decision for themselves. That's really ultimately what I'm trying to do in any situation, is give somebody whatever information they feel like they need so that they can make a good decision.
I think if I was Steve Champion and I was your broker, I would advise you to tell, just as you have done today, the truth, the whole truth, and nothing but the truth. And let them know what you've done the last 3, 4, or 5 years to try to turn your life around. We all have a history, especially real estate licensees. 20% or so of the people who get their fingerprints taken have a match. For whatever reason, I had a match. Maybe some of you people did here too. And that match wasn't for anything I was real proud of at the time.
I plead the fifth.
You do what?
I plead the fifth.
No, don't do that. So I can see that as a problem.
Sure.
I can see if you're competing for a listing, some unethical agent might say, "Hey, you know that Carter guy, he's been in jail."
Right.
And you have. You can't change that.
That's right.
But you've changed yourself over the last several years.
No, it's absolutely true, and it's something that something that goes before me everywhere I go. So it's something that I have to stay humble enough about to be able to get into those situations and still perform well.
And I'll follow up then to you, Jeff. So if somebody says, "I'm not going to list with you because of your criminal history,"
then I can refer them to someone better.
refer them to Steve to see,
Right.
to see how he can help.
Right.
Okay, just want to make sure. Jeff.
Well, and this from Ms. Matlock, we're running into what it seems to me to be the Fresh Start Act again in this circumstance, or?
If you were to deny him based on his past conviction, yes.
Does it come into play even though that it's been several years since his parole ended?
Yes.
Okay. Mr. Wood.
I guess my concern is, I mean, a lot of times we have people come here and go, "Oh, I need a second chance," and I think when you got parole, you got your second chance,
I agree.
and then you messed it up. And so this is because you got in trouble while you're on parole.
Okay, I got you.
So this is a third chance, and because of that, I'm not maybe as I guess able to overlook it. The only thing that gives me any concern about that is the man that's sitting next to you, because I think so much of him.
I understand.
And that's where I'm conflicted right now. So and that's just my concern. I think Commissioner Grease has opened up a valid point about how you're going to handle that, but that's something, y'all, if this happens, you'll have to work with that. But also too, I think probably you are a good example of why it's important for people in the ministry that work in the chapel and the prison system. And I have great appreciation. I'm working with a client right now that he was a chaplain in the prisons, and he never could refer to his children. He was taught never to refer to them by name. He referred to them as ABCD, because they're bad people in prison sometimes, and so he never could refer to his kids by their own names. So,
Right.
But that's my concern.
I understand.
So
It's warranted.
okay.
Other comments? Questions for either party? If not, is there a motion?
I'd like to make a motion that we approve his application.
Second.
All right, the motion on the floor offered by Ms. Franks and seconded by Ms. Hills, if approved, would allow Mr. Carter to proceed to get his affiliate broker license. Discussion on the motion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no.
No.
That motion passes on a 5-aye, 1 no vote. Mr. Wood votes no. Gentlemen, thanks for coming up from Chattanooga. Be careful going back.
Right.
Good luck.
Thank you.
Make that man proud.
I'm going to try.
All right. See you, Steve. All right, next up, Tiffany Owens.
John, can I make a comment on
Sure.
the way up?
If you'll hold 1 second, Anna, go ahead, Fontaine.
Yeah, it would be very helpful when we have a rule change like this Fresh Start rule, if we got a printout of it to put in our book so we can have it. There's several rules that have changed since we have these books.
Right.
And-
Well, the Fresh Start Act is a statute, so it wouldn't go in your book because it's in a different title, and this is only for like Chapter 13 for our book, so it wouldn't go in there. But we should have. You have the paper copy we sent around of the Fresh Start Act.
I don't know. If I do, I don't know where it is.
We'll get you another
So what
copy
Ms.
of
Taylor
it.
is asking is when we get these every month, if in the back of it, that paper copy could be there so we could just refer to it.
Right.
We're
Okay.
not good about keeping track of stuff.
Okay, we can certainly print out a copy.
I think last month we had to remember to put it on your iPads.
Oh, some of us don't even know how to use an iPad.
We might be able to add it to your blue. You have a blue, the clear.
This book that we
Yes,
don't know what is in there.
The
Yeah.
thing is, I'd like to have one at home with my book, so when something like this comes up, it is a statute, but we just voted.
We could probably print it out for you before you leave today.
Thank you
can
very
also
much. That is a
email it.
right answer to the question.
Thank you. But other things like that, it's nice for us to have the latest.
While we're going over the legal
Right,
documents
right,
at home.
Right, thank you.
All right, so which one of you is Tiffany Owens? All right, and you're her broker? May I have your name before we get you sworn in? Susan Jensen. All right, Miss Matlock, if you'll swear in Miss Jensen and Miss Owens. All right, ladies, if you both have a seat. The two people in front of you were particularly good about speaking into the microphone, so if you guys will make an effort to do that, this is being recorded, and people up here as well as not being too literate with iPads can't hear very well occasionally. I'm not pointing at anybody in particular.
Okay.
Could be the
Okay.
chair. All right, Miss Maxwell, what do we have?
Before you have applicant Tiffany Owens and her principal broker Susan Jensen. Miss Owens has taken the real estate affiliate brokers exam. Her principal broker Susan Jensen was first licensed as a broker in December of 1986. She's with firm Realty Center of Chattanooga, doing business as Berkshire Hathaway Home Services Realty Center. A summary of the criminal and disciplinary sanction is misdemeanor theft by shoplifting, and that was in February of 2011. The disposition of the misdemeanor charge has been satisfied, and their statements can be found on your iPads.
All right, Ms. Matlock, just for background, the reason that Ms. Owens is here today is because a shoplifting charge or conviction requires that she show up.
Right, any misdemeanor involving theft of services, money, or property requires you to come before the commission in past 10 years.
This happened in 2009,
2011.
11, okay. All right, Ms. Owens, you saw how this went with the previous applicant. Would you give us a little background or tell us what you'd like for us to know about what happened, what you've been doing since, that kind of stuff?
Yes, sir. So this actually happened in 2009, so it's almost been 10 years now. I was with a friend at Walmart that day, and she happened to steal, I don't even remember what it was now, a shirt or some jewelry or something, and she had it in her purse. And both of our purses happened to be in the buggy, so since they had found something on her, they basically told me I was guilty by association.
So what happened?
They ended up taking us to jail, and I had to bond out, and then I went back and had to do community service, pay fines, and was not allowed to go to the Walmart for like a year or something. But during the court process, after I'd already signed the paper and pled guilty because I didn't know what else to do, I was really young. I was like 21, 22 at the time, and so I'd already signed the guilty verdict and handed it to the judge, and I was like, but sir, since they didn't find anything on me or my person or my purse or anything, I was like, well, why am I even getting charged with this? He was like, ma'am, if you would have mentioned that before you would have signed this paper, then I probably would have just dropped the case against you. But I had already signed it. He already approved it and everything. So
Since that time, what have you been doing?
So I've had 3 children. I've gotten a college education. I've recently done this. I was the CFO for 21 Liberty Tax stores all the way from Nashville to Cartersville, Georgia. So I did all the audits and everything for that for 7 years. Got a bachelor's degree in business management. So there was like a 2-year period in my life where I was kind of wild and trying to figure out who I was. And so I had a couple of different things in that period, that a DUI, some possession of marijuana, different things like that. So I'm not really proud of those 2 years of my life, but I haven't had anything in like 10 years come against me. So
Sometimes we don't need to know certain things like...
yes, sir, or certain people, or certain people.
Just for the record, Ms. Matlock, DUI or possession of marijuana has nothing to do with why we're here, correct?
Yes, correct. That's why it's redacted.
I want to make sure.
Okay, so that was my first question, because, and my iPad is crazy and I have nothing coming up, but as I recall, at the very bottom it said conviction number 4, and 1, 2, and 3 were redacted. So those are the things that. Okay.
I noticed that too.
Okay.
If it's redacted, those are circumstances you're not supposed to consider. It doesn't fall in to your purview.
All right, so we're here on the shoplifting charge only.
Yes.
Okay.
Only.
And what was the date of that?
2009, like March. I think the court date was like April 16th, 2009. So Mr. Aaron actually told us if we wanted to wait, then we wouldn't even have to come before you because it had been the 10-year mark, but we wanted to hurry the process along. We don't want to wait an extra 2 months. So.
All right, questions for Ms. Owens?
So you pointed to her and you said, I've been doing this. What does that mean? When you
Real estate.
So what have you been doing in real estate?
Just doing the education, and I went to do the testing and everything, and I've just been doing my own little research on the side and stuff. I did like 1 day of training, but I can't really do much without a license or anything or the MLS, so.
So you're not an employee of the real estate company?
I have actually signed documents with Ms. Jensen.
So are you getting paid as an employee to do work there now?
No, I'm not licensed.
Okay, so I looked this up. Something just was not ringing true to me. And I looked up your LinkedIn account, and it says you're a real estate agent at Berkshire Hathaway Home Services.
I'm signed. I thought that meant, well, I'm not licensed.
Do you have a
yet.
license?
No, ma'am.
I just thought your
So
broker.
should I change that?
Your broker needs to know
Okay.
and have a little more. You're going to
Oh, I
have to
didn't know
watch
that.
what she does, I think, as far as things like that.
Okay. I'll take that down.
Other questions?
Well, if you get a license, you can leave it. You can
Yeah.
leave it on. I'm
Well, I was just trying to
I'm
let
just
people know,
making your
hey, guys,
broker
I'm
aware
running
that
the
you're
business.
holding yourself out as a licensee and you're not.
Yes, ma'am. Okay.
And to follow up on that, you're not a licensee till you take all the information, send it in, and get something confirmed from the TREC that you are now licensed.
Bobby, don't you have an observation about how, do you make this observation occasionally about how people get charged just because they were with somebody?
I made this motion or made this discussion last month. in all the years, I guess I've only been in this about 3 years, but we've never had one person that's ever come before us and ever said, I'm the one that stole it and I got in trouble. It's always been somebody who was with the people who stole it.
This case, I honestly didn't do it, but
Oh,
the DUIs, the marijuana charges, that was all me.
I'm not throwing stones at you, ma'am. I'm just saying, I think it's funny that in all this time, I have never heard anybody come back and say, we did it. I did it, and, I don't know that that's would change our outcome, but that's just, at some point, the law of averages are going to come up, and every month it's going to be, I'm the one that stole the bacon. I'm the one that stole this, but we haven't had it for 3 years yet. So.
We had bacon stolen.
All right.
Yes, I know we've had people that stole bacon, peanuts. I mean,
Mascara.
we got great stories. We got great stories.
All right, Ms. Taylor.
Just for my information, was
Yes,
the
ma'am.
marijuana and drinking before this or after this?
Before.
Okay, thank you.
What caused her to go
That's why they were
to
conviction
Walmart?
1, 2, and 3.
I think when they said that you couldn't come into Walmart for a year, I think that was a good thing. That was not a bad thing.
Well, actually, I was supposed to be leaving in like 3 hours to go on a cruise. And so I was like freaking out because I'd already paid all my money and had our tickets and everything. So I was kind of just like, this could happen at the worst possible time,
So what kind of real estate are you going to be doing?
Residential to start off. I eventually want to get my broker's license after I do the 3 years and do some more education.
And you're in Chattanooga?
Yes, ma'am.
All right, Ms. Jensen, did you hear anything new today that you hadn't heard before from this applicant?
No, sir, I didn't. I've heard all of this.
You heard the marijuana and...
I've heard of all of it.
All right, just checking.
Yeah, she told me.
Tell us why you're interested in having this lady affiliate with your company.
Well,
Speak into that microphone, please.
yes, I was introduced to her by another broker in our company. We have 5 offices. And she knew her through another business and knew that she would be a good salesperson. We met and then found out she also knows my son and daughter-in-law, and so they know them through another business as well. So she's got a good reputation. She's a hard worker and has had other businesses that were successful. She was in management, so I'm excited to have her on our team.
Questions for Ms. Jensen, Ms. Owens? If not, is there a motion?
Motion to approve.
Second.
I have a motion by Ms. Hill, seconded by Mr. Wood, that this applicant be allowed to proceed to get her real estate license. I have a question for you after we finish this vote. All right. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Owens, you mentioned Liberty Tax Service. Do you have anything to do with that person who stands out front dressed like a Statue of Liberty and waves at people going
We
by?
were actually talking about this on the way up. And, people think that it's the goofiest thing ever, but they bring in 60% of the business. So,
Do they really?
Yeah.
Wow.
I
do think
always
it's a
pass
good-
them and say, bless their heart.
I know. And they'll be out there in the rain, the snow, they don't care. So,
Those people
it's
get
good.
paid a lot of money.
No. Just like $8.50 or whatever minimum wage is. I don't even
Do they have to buy their own outfit?
No, they do provide that. So.
Don't they wish they did?
All right, ladies, thanks for coming up. Best
All
of
right,
luck
thank
to
you
both
so
of
much. I appreciate
All
it.
right, take care.
May I say, my iPad is just circling, and I didn't copy
I've got a
out.
copy of all
And for that reason, we're taking a 10-minute
That's right.
break.
I didn't copy out the notes.
I did, so.
I copied out the notes, but they're on my desk.
Report. I wanted to wait till she got a cookie before Take your time. We can discuss other things for a moment. You
I have-
finish that up.
I have a couple different updates for you guys.
I can't understand what you're mumbling.
Mr. Chairman,
Yes, Mr. Diaz.
do we want to wait for Mr. White to join us? Because I know she has a little bit about the discussion for the education portion.
If we have to wait for Mr. White, we could be waiting for a long time.
Well,
I don't know when he'll be here.
I have some other updates for you guys as well. That
Okay.
aren't. I'll say the education for last, just in case you can make it back. First, I wanted to let everybody know that your 2019 conflict of interest should be printed out for you at your space. If you could just complete that and sign it for us before we leave today, we'll
If
make
there's
sure.
no conflicts, we don't sign the second sheet. Is that correct?
You just sign it. You don't put any conflicts down.
Okay.
So your licensed daughter might be a conflict.
Yeah, it's.
So I put Judy down.
I always think it's better to put more than less. You know, if you have anything that you're even thinking about, just go ahead and put it down. We'll have it reviewed and make sure you're compliant. I also wanted to mention the spring conference. I know you had all received an invitation to sit on a panel for the spring conference, and just kind of wanted to get an idea so I could relay how many will be able to attend.
Would you remind us what date that
It's
would be?
spring
Yes.
break.
It's March 19th. It's a Tuesday, and it's the week following our meeting, and it's at 2:15 p.m.
I will be in Disney World with my grandson.
For the record, Jeff, in particular, because it's maybe the first you've heard about it, this is not a required meeting. It's strictly voluntary. You don't get reimbursed for mileage, food, or anything. The Tennessee Association, or the Tennessee Realtors, TUR, has invited us each year to come and have a panel and talk about topics that we think might be appropriate for their membership to hear. It's generally well received, and generally we have 5 or 6 members of the commission that can, with their schedule, make it. So, with that said, I'm pretty sure Ms. Frank's not going to be there.
I will not be there.
Bobby,
I'll be there.
I expect I'll be there.
I will be there.
Fontaine,
I will not.
okay.
I will.
Okay, so,
That's 4.
and Austin might be.
So I'll follow up with Austin and Rick,
And Rick.
separately, and then that way I can get our expected attendance over. Okay.
Frankly, if any commissioner who says today they're going to be there, something comes up, there's no expectation that you need to show up, all right? All right, with that said, thank you.
Thank you.
For bringing
Yep.
that up.
Okay, the next item that I wanted to update the commission on is E&O. So this is a very hot topic right now at the commission. It has been, a lot of phone calls, a lot of emails. But I wanted to give you a quick rundown of sort of the last month. As most of you know, a majority of licensees' E&O insurance expired 1/1/19 or sometime in January. We sent out an email to all of those that we were still showing as expired or expecting to be expired on 1/14. That went to roughly 8,600 licensees. We saw some benefit with this, and then we saw, some issues. Luckily, we were able to get them resolved before anyone was suspended on 1/31. One of the most common issues that we run into with E&O is names. So if your name is not exactly as it is with the commission, with your insurance, then it is not going to correctly upload into our system. So shortly after that email, we were able to get a large number of licensees corrected. We worked with Rice and made sure we had some people more intelligent than myself that are able to do VR lookups, and so we were able to get their listing of licensees exactly as they are in our system. And so that was successful in getting all those people in the accurate status. And with E&O on their account.
Would it help to go by numbers instead of names? I was one of those named people because Rice has me as Marcia Apple Franks. State has me as Marcia Frank. So I got a letter saying that I had not gotten my E&O. She immediately got it worked out for me, but
yes,
I'm just wondering why.
So why I have asked that. Currently, the way E&O works is very similar to education. Our big providers send us what we call feeds, but are actually spreadsheets with all of the licensees that they carry the E&O for. And then that gets uploaded into our system that our IT department helps us with. And currently, first name is a required field. And before we started this process, I asked about removing that. And it's a change to remove that. So at this point, I'm working towards that for the next big renewal cycle so that we don't run into this the next time around, to where it can only require probably license number and last name. That way it has the two identifying factors. But so from that email, we showed, we used it, My Emma, and it is a nice resource because it can tell me exactly how many people opened the email, how many people clicked on the different links within the email. So of the group that we sent it to, 94% of it was delivered with 6 bounce backs. The bounce backs are typically people that maybe have changed your email and didn't let us know, or maybe people who no longer have that email account. And then from that grouping, 56% of those people opened the email. So they give us a rating as to whether that's good or not. I don't think we're ever going to get everybody opening our emails or everybody looking at them. But so on 131 is when we ran the full suspension report of anybody that wasn't in compliance. At that point, 3,627 licensees were suspended. As of last Friday, this has gone down to around 3,091. So we have sent out letters to, by statute, we are required to send a letter to the licensee at their firm and their main address, and then we're also required to send it to their principal broker. So there's 3 letters that get sent out for one individual person. Those went out last week. I think we haven't seen the full effects of everybody getting those just based on phone calls. Unfortunately, it's not like we send the letter or we, suspend. The letter has to go to our state postal office and then sorted there, and then from there it goes out. So I would expect that people are probably getting those today and this week. And then per the rules, once somebody has been in a suspended status for, I believe, 30 days, that is when the fees start accruing after that. So principal brokers and licensees have a little bit more time to get in compliance before any penalties or discipline start accruing. So there'll be more to come, I'm sure, at least the next 2 meetings on this. But just wanted to give you a quick update of where we're at with E&O. While I know all the staff has been working very hard when it comes to the increased emails and phone calls, and it also ends up affecting other aspects such as license approval, because we can't approve anybody or do anything with anybody that doesn't have E&O. I think it is significantly in a better place than it has been in the past with making sure that we're accurately suspending the correct people and getting them fixed and whatnot. So does anybody have any questions?
Yes, there are questions. Ms. Taylor.
I know that last year there were several groups of companies who did not have were insured by other people, that the whole company had issues. Are we having more of that this year?
So I think we'll definitely know more of that when we start getting these people that are getting their letters and then, they're responding with their issues. I will say, I think any of the big companies, we sorted through that last time around. I do think the smaller companies, our rules require that the individual carries the E&O. It does not require that the firm does. So, I think really it's best for us if we get it in the format that we can upload all of them at once. Sometimes people will just send us one policy without any licensee's name on it. So, figuring out those situations. But I think I have not seen too many of those, but I do expect to have more of an update for you once people are getting the letter and then we're sorting through their issue.
What I meant by that was, of those companies, some of the companies were putting in that information, and for some reason there was a glitch that wasn't being taken. Is that been a problem this year?
So the way that it works for us is we upload that report. So, we might have, 5 different providers sending us spreadsheets for the day. And we get a report back of which ones were successfully uploaded and which ones were not. If there is a whole spreadsheet that didn't run correctly because maybe they don't have it in the format that is needed, in that scenario, we would typically reach back out and have them correct the format and make sure that we get it in the correct format. When it's just one or two people, typically the staff is manually fixing those. And that happens a lot with whether they put the wrong license number, so that doesn't match, or whether it's the first name. So.
Ms. Hills.
I just want to, we did receive 2 letters, not from this mailing after January 1, but before, and I was just impressed, one, that the state was on it so fast. So I really thought it was this mailing from the...
Was it the email that you got?
No, we got 2 letters. One was for Clarissa and one was for another agent. And it may have had to do with the name matchup.
Yes.
And so it sent in the
Correct. Okay.
certificate where they had paid the E&O. But I was just, I just have to tell you, I don't know what triggered that, but I was impressed. I thought, oh my gosh, they are just on it. So
Yeah. Well, I think
hats off to
each
y'all.
time it
I mean,
gets a
this
little
is
bit
the same thing you
better.
got. Yeah. So, thank you.
Okay, good.
All right, so here's a quick question. So you talked about our rules and insurance. This is a statutory requirement, correct?
It's both in the rule and the statute.
Okay. What part is in the rule?
So I think the rule more so defines the penalties. So, after 30 days is when, after being suspended for 30 days, if you backdate your insurance, then it's a $200 fee. If you don't, there's a period from like 3 to 6 months is this, and then after that. So that more so defines specific penalties, and I feel like the statute defines who we have to send the letters to, that they require. It's,
Statute set minimum requirements as far as insurance, or is that a rule?
as far as the limits.
Yes.
I think it generally says, and this is generally says that it should be established by the commission, and that it should be we should offer a contract with an insurance provider that should be offered to all licensees.
That's good. So let me get these dates straight. For most people, not all licensees, their errors and omissions insurance expired December 31st. So on January 1st, they hadn't bought it, they're delinquent.
Yeah, their technical end date of their policy was 1/1/19.
Okay. So our rule or policy gives them January free, right? There's no...
So it doesn't specifically define those dates, and that is partially a decision that I made due to the fact that our last day of work was Friday, December 28th, and our first day back was January 2nd. I think, just from the state insured provider is Rice Insurance. So we've been back and forth a good amount throughout the whole month of January. Well, they had a significant amount of licensees all renewing between this 4-day period where no one's working. So we sort of elected to suspend once we got all caught up, and that way we're not suspending people that really shouldn't be suspended.
Okay, so January 31st, the significance of that date is if they haven't got it done by then, are they suspended as of that date?
Yes.
All right.
So that actually ran overnight, and we got the report of everybody that was suspended on February 1st.
So they're suspended. If during the month of February they get their insurance in, are they going to pay a penalty at all?
They do not pay a penalty in February. They will pay if they do not have it in by March. So 30 days in suspension, after 30 days in the suspended status, after that is when the penalty starts to accrue.
In reality, in February, if they're suspended, they're not practicing real estate.
They should not be.
Okay. And at least the state policy has, if they pick it up in the first 60 days, it has has coverage back to January 1st.
Yes, they can backdate it, and that is specifically outlined in the rules that if the policy is backdated, the fee is one thing. If it's not backdated, So if there's a period where they were without coverage, then there's a different fee.
And do you contact them by letter or email before the February 1 date?
They are
So that
contacted
they
by
know
letter.
they're going to be suspended?
They're contacted by letter to let them know. Oh, before the February 1st date?
I mean,
Well, we sent that email on January 14th to let anybody know that anybody that we in our system did not have insurance for, really for the whole month of January, we went ahead and sent the email, and really kind of into that beginning of February.
I think that's a good courtesy to do that, too.
So, but this may be for future, another topic later today, but can somebody electronically change their email address with the state?
Yes.
It's easy to do.
Yes. If they have a core account, it's easy to do. And I'll just do my own little plug here. I would like to see more and more people keep current email addresses because, one, we would like to start using email for notice reminders more. And then this My Emma tool is really nice for a specific group that we want to target. So, we did it, I mentioned it probably in January that we did it for our education providers and instructors, and then did it again for this E&O potential expiration.
And I wasn't involved in it, so I'm just curious if it was just during this window, but there were a couple things that changed. I don't know if we got new licensees or something, and no, it wouldn't have been new. It was maybe transfer, and they had to, when they did it online, they had to upload the receipt for their E&O, and I thought,
So we weren't able to approve anybody that does not have current E&O. So think
will
we-
it be a thing that continues on now, even after this day? Because I found I was pulling it out of my file. I make everyone give me their thing, and I was pulling it out of my file anytime somebody went to do something.
In that December to January period.
Yeah, I
like,
was thinking it was December.
The staff processes different applications such as the transfer, and then they send it to me. Well, I can't approve anybody that doesn't have current E&O insurance because the system is looking for that. That's one of the checklist
Yeah, and it
items.
would make them upload, so they would be looking for their certificate and then come to me and say, well, how am I doing this? I have my license, and I'm just...
Well, and I think we were seeing it with a lot of initial applicants too that turned in their application in December, but they didn't buy
Yeah, that's...
that
yeah.
E&O.
Mhm.
They
it
bought
wasn't new ones. It was...
But it wouldn't if they didn't have, if we hadn't gotten their insurance from their provider yet, and it wasn't on their file, then it would not let us approve them.
All right.
Do we know how many people do not go through RICE?
So I
Or
think
percentage?
I think based on the numbers that Cindy has provided to me in the past, the number of people that do that they have insured with them compared to our total number of licensees ends up being about roughly 80%.
All right, Caitlin, what's next on your report?
So next up, I was just going to give a quick update. I don't see that Ross is back, but I feel like I can adequately discuss this. So in between last meeting and this meeting, myself, Ross, Anna, and Denard all met to go over sort of a go-forward plan for correspondence courses and really education in general. And some of the ideas that we came up with were sending out an email to the providers, sort of asking them questions about correspondence courses and a survey about other courses as well. And then we were talking about taking that feedback that we got from all providers and hosting a roundtable for all education providers. And we sort of saw it as being about correspondence courses and then also about sort of the future of education and where it's going and sort of discussing it with all of those key providers that are licensed with us. And then another thing that we discussed was potentially starting to conduct a random audit of courses on a monthly basis and treated similar to how we treat our other audit of firms. So it would be a random selection of courses, Ross or another, probably Ross, the education director, would be the one to audit those. And, you know, we would work with legal to have sort of a set of criteria to see whether they were meeting it or not meeting it, and whether they were in compliance with what we have in our education rules. Let's assume they're not in compliance. We would work with them to try to get them in compliance, sort of tell them what we found in their course, and then allow them the opportunity to correct it. So it wouldn't be necessarily a disciplinary matter. It would just be purely to get people into compliance. So those are some of the different things that we discussed. Let me see. I wanted to make sure that I can tell you this. We also, the whole department has a request for proposal out for.
Interrupt just for a second. You have to check with Anna before you can tell us stuff.
No, but listen, if I say something I'm not supposed to say, I'm going to say Anna told me I could say it. This
then the answer's going to be no every time.
No.
This has been posted to the public, but we have a request for proposal out for an education platform that would hopefully for free provide a lot of the services that I've been looking for us to provide when it comes to rosters and licensees. And so that's been out there posted. We have to go through a long process before we add any new vendors with the state. But I think it would also help some of the issues, one that we've been having with rosters, which is separate from this. But it also allows for licensees to potentially rate their course or rate their instructor. So that's an added feature that, you know, I know Bobby has mentioned that it's typically handled through the free market, but it would also allow for it through this platform.
Speaking of Bobby, I'm letting him take the microphone for a minute.
Okay.
You've been just whatever you want to say. You for 30 days you've been thinking about what you want to say.
I've been thinking, let Caitlin keep going. I'm fine right now.
All right.
I would like to say one thing. The National Association of Realtors requires their members to have an ethics class, and you've got to have it by December 31st. And it just seemed like all December, everybody's, have you had your ethics class? Have you had your ethics class? You know, I'm one of those procrastinators. I had not had mine. I had 4 different people tell me which company to get it from because the answers are at the back of the syllabus.
Well, you missed last month.
Oh.
Go watch the video.
Yeah. Last month we had a.
Okay. Good.
Miss Taylor. Miss Taylor.
I have some real concerns, and I don't know whether this is appropriate time or wait for Ross to come back.
If it's related, let's go. Let's talk
Well,
about it.
I think like the people that came here last month that we looked into or presented their thing, it's quite evident that they're not following the real rules here. And that is, how are we seeing that these people, I know you said what you were going to do, but I just don't understand how a school could be going on for a lengthy time without following the rules and having the answers given and then not really checking them when they came in. You have no grades, you have nothing. It's pass or fail. And they're not, and it says they're using the printed materials course. So it says it must contain at least 6 written exercises that are to be submitted periodically to the instructor, graded, and returned to the student. That's evidently not happening at all in that particular instance. I don't know how many instances there are. But if that's not being done, how do we know it?
Well, and that's why sort of when we met, we discussed, one, I think giving providers a heads up that we're taking a stronger interest in this going forward. And then 2, that's why we would do the random audit, because, currently we get the course in and you review the proposed outline of the course, and then, it gets approved, and we don't really hear about the courses unless we have somebody that emails us and lets us know, or really if somebody lets us know. So sort of this compliance random piece would be to address what you discussed.
Well, I don't understand, and they're evidently not even grading them according to their answers last month. They're not even grading them. They're just looking to see if the blanks are filled in. Could we that the answers never be given? That's what the school is supposed to do, is grade them and give the answers.
Yeah.
So I may make a suggestion in a little bit, but let's hear from Jeff and then Bobby.
Well, I just want to ask the question, should we implement all these new oversight options that you presented to us today, and we find that a school or somebody who's taken a test is in violation, what authority do we have to impose sanctions under?
So I'll speak and then I'll let Anna speak. I think we would try to work with them to get in compliance, and we could also do somewhat as we did last month, essentially represent the course to you for approval or withdrawal.
So the only consequence to the school would be that the course is withdrawn?
Yes. Is that, do you want to?
I only see in areas like Caitlin said, the course being withdrawn, and then I don't really think that, because we're looking at education instructors and schools, it doesn't really fall under the same kind of disciplinary realm and statutory authority we have for those kinds of sanctions and consequences. So it wouldn't be through the normal complaint process, which is why we brought the school beforehand to withdraw approval of the course that way. Or if we find it, that's the only way. It's difficult for us to know about this unless someone says something. So that's why we were looking further into the inspection portion, which we have. The rule says we can inspect courses as need be and do it that way.
But just to be clear with Jeff, but we are only over the course and the instructor. So the fact that we talk about a school, that doesn't exist in our realm. Is that right? Will you just help my memory?
Right, because
Okay.
Schools aren't licensed. It's and Caitlin, correct me if I'm wrong, it's the individual instructors and the courses that are licensed, not the school. So you would have to know about the specific course and the specific instructors. And I'll have to remember that looking at courses there is a different kind of standard for courses than what there would be for an instructor. So the instructor requirements are a little bit more general, so you would have to make sure it would have to be something egregious. So for that to kind of happen. But if we're looking at the courses, I also would just like to point out that specifically for the printed courses, any course that is under 8 hours, as per the rule, you don't have to have a written exam. So those are only 6 written exercises are provided. So if the course is over 8 hours and it's printed, an exam is required. So I just wanted to throw that out there for you.
So this commission, of course, has the authority to approve courses. If we withdraw approval, can we withdraw approval for more than one course that's under suspicion, or are we limited just to that one course that's under suspicion?
So we would need to know the specific course, and then we would review it course by course as if we would look at different complaints. We can't just, so ethics course comes before us, we withdraw approval, and then someone would say, I know they're doing about this and this, with their other core courses or something else. We would have to need specific courses identified. But then if a course is removed, we would like we were saying, we don't really want it to be as punitive. We want it to be a collaborative effort so we can get the schools in compliance, because it's clear that there is some kind of disconnect between the rules and what the commission would like and what is being provided to the licensees. And education is important. We want to make sure that our licensees know all of the tools to have them be successful. So,
And the reason why I'm asking these questions is because I know that we're going to give our sense and we're going to collaborate with all the educators. And once we help them get into compliance, if they violate the education standards, somebody's going to have to be the sacrificial lamb and be the first one to suffer consequences. So I wanted to know what our authority was.
yes, you absolutely have the authority to withdraw courses. You even have the withdraw approval from courses, and you even would have that, I think, even before we took corrective measures before that. But we were just telling you of a proposal that we thought what might be a great way to remedy this instead of having some kind of mass course list that we go through and remove approval from.
Bobby.
Okay. We got 3 different ways we do classes right now. You got a classroom classes, you got internet classes, you got pen and paper. I think the pen and paper came about before we had the internet. All right. Now that we have the internet, there's really not the need for pen and paper classes anymore. Okay. At least with the internet classes, they can be timed. I mean, in some class, those you have to literally sit there, whether you're listening or not, doesn't matter. I mean, I've had students in my classroom that I'm not sure they were listening, but they've had to sit in the time. The pen and paper does not allow that, or there's no reason to no way to keep up with that. So I think we're at the end of the usefulness of pen and paper classes. Okay, and so I mean, now I think classes get approved. Is it for 2 years? And we just went through that cycle. So we've got basically 2 more years where we've approved them. But my other issue is this. So that's my first thing is I think we need to think about doing away with pen and paper at some point. Maybe saying we're not going to renew anymore at the next cycle. You have to be classroom or internet. That's one issue. The other issue is this. If you have a real estate school and you get called before the real estate commission, and you sit here and you testify that, hey, we're just sending out the stuff and we're not grading it, and yeah, we're sending out the answers. And I think it was real easy last month for that school to realize that the commission was not happy, and then you turn around and email it another class out again. I got on February the 4th and did the exact same thing again with another class. You're either stupid or you don't care, all right? And it may be both. And that's what's happened again.
Money makes a lot of people stupid.
And I mean, and I think this group, that group that was here, we need to go ahead and take down and pull back approval for every one of their pen and paper classes that are post-license classes for CE credit, because they don't care and they're making mockery of our continuing education.
May I respond?
I want to make sure he's finished first.
Okay.
I'm not finished, but go ahead.
Okay, go ahead. Go ahead. I'll get you.
That was, and I don't think they're the only one. Okay, I mean, we've heard rumors for years about stuff, and I was frustrated that here they're telling us they're doing it, and I got the feeling that maybe within Trek, I mean, at least somebody was saying that they had heard about it before. And we had point blank asked, and we were told it was not going on. And then they got here and admitted that they were doing it. I mean, that's not smart. And that's not, I mean, and of all things, they were sending out the answers to tests, and it was an ethics test. I mean, there's a problem.
Okay, Anna.
I'll try and start from the beginning. If we were to phase out pen and paper courses, that would require a rule change. We would need to remove those. But I also want the commission to think about the removal of pen and paper courses in general. Even though the internet is readily available, it is not accessible to everyone. It is accessible, more accessible. You can go to libraries or those kind of things, but we need to think about our licensees that may not be as internet savvy or they don't have the access that everyone does. Like, it is. I know it seems like it's a common thing these days, but honestly, internet is it's kind of like a privilege and a luxury that not everyone has. There are definitely some safeguards that we can do to look at that and address it. But if we were to do that, it would be a rule change. And I think if we were to do a rule change, it would probably be more of like a rulemaking hearing, because that would be a drastic change from where we were going. But that's down the road. As far as the school that came before us beforehand, it's possible we could bring them back and have that conversation again. I don't think that we don't have the authority to just go ahead and just, retroactively remove everything. I think having a school come over and explain everything is a great idea. Give them a chance to give the opportunity to explain it. And we would also, for these specific courses, would need to know if they were the 8-hour course or anything less than the 8-hour course. I think the biggest problem we saw beforehand was that it wasn't necessarily the answer key. Like that's obviously having a key is not great, but the fact that the school was not grading the courses, that, as Commissioner Taylor pointed out, they weren't following the specific rules to grade and look at the courses. So anyone you could get an answer key, or like you were saying, they could do a Christmas tree on an answer key in any form or fashion. But if you're grading the courses, I think even if you provide the answer key to them, it would give them, they would have more of a responsibility to make sure that someone is not just submitting this, hey, we just did that. But then we could also, not having an answer key period would be beneficial as well, because you would need to know what you got right and what you got wrong. But again, I think that's just going to require some more communication on our end, and we could probably do that as like some kind of blast or communication to all of the providers to let them know, hey, we're looking at this. But if you certainly see things, or if another individual sees something, let us know so we can have it on our radar. We just can't go off of murmurings. We have to have individual input in like concrete evidence. Or
they came here and admitted it to us last month. I don't think bringing them back in here is going to help, because it didn't take. I mean, they could get the gist of that. We didn't like the fact that they were sending out the answers and not grading, and they still did it again. I think we've said, hey, you need to do something, and they basically told us stick it in our ear, and they're going to do what they're going to do.
Right, and we presented to this commission just last month, and it was decided not to take a vote after that. So I would just like to say we decided to defer that. We could bring it back up again, and they don't necessarily have to come. That's not a requirement. That was a courtesy that we extended towards them. But I don't think it would be a good idea to rehash that at this particular meeting right now.
But you have no way, on a paper and pencil, you have no way, no one has a way to time it. And our education is based on hours. And we give hours specific. You get, somebody will give them an 8-hour class they've got to take. If they do a pencil and paper, they can get their broker to do it for them. They can get anybody else to do it for them, and they can do it in 20 minutes and not 4 hours. So there's no way, regardless of whether they have a computer or not, that it can be timed. And that is in our rules and law. And we, to just say it's hard for someone. Sorry, but we can't time it if it's pencil and paper. There's no remedy for that. Do you agree?
I think the way that pencil and paper goes, I'm not sure that we have a lot of pencil and paper courses that have a high hour number. that would be like.
It doesn't matter about the
6
high. It's
Right.
it's specific hours we're giving them.
I understand, but it depends on what all is provided in the course. So if you have like a whole booklet full of information, I think that would take maybe an hour or two to go through it. But I think you could also say the same way for internet courses, you can be doing other things on the internet while a timer is going.
But at
So
least it's being timed.
It's being timed, but it's not necessarily meaning that you're paying attention. You could have in the background and click through it. So we have.
I think we need to do something about it.
Let's go to Ms. Taylor for a minute.
I think so too. But in this particular group that came last time, if I remember correctly, there was one particular person that wrote the courses, correct, and was in charge of them, and then the other people were just helpers, so to speak.
Right.
So the instructor is in charge of making sure that the exercises were to be graded and returned. So that person is really in charge of it. Now I'm not for anything they did. I think it's a disservice to our agents to be able to take courses like that where the answers are given. I think it's truly a disservice, and to the public, because they're not learning if you have an agent that hasn't learned what they're supposed to do. But is there some way, for instance, on the instructor, are they reviewed every 2 years too? Is that correct?
They renew every 2 years as well.
And that instructor, from what I understand, has been really ill for a long time, so hasn't been a participant in this whole thing for some time. His staff has been sending out the instructions and receiving the answers. Is there a violation there? Or is there something, not violation, but something that can be changed in that?
Let's let me just get clarity on one point. Anna, you agree that we talked about this particular school last month and agreed to continue discussion about the topic this month.
Yes.
So it's properly on the agenda today to discuss. I know it's kind of morphed off a different topic, but you're okay with us discussing this topic because we continued it from last month.
Right, because and it also just falls under the realm of the correspondence courses.
Right. And so if at some point somebody wanted to offer a motion related to the school or the topic, we're in order to do that.
Yes, but I would not towards the school because schools are not licensed.
But it could be toward a course or toward an instructor.
So are there other instructors at this school? Because the stepdaughter, if I recall, said that the owner of the school was in
I think we need to
assisted
forget
living.
about the instructor. It's the class. It's
Okay.
the class.
All right. So
But do they have any instructors besides the one?
I'm sure there are.
Okay.
And I think they do some classroom classes
They
too.
do. They do classroom classes, and they let you out about half a day early each time.
It's hearsay at this point.
I don't know that.
I'm just asking.
No, I have agents tell me that.
Okay, that's hearsay. I'm not a lawyer, of course, but it sounds like hearsay to me.
Maybe I should take one of those courses.
There's this matchbook you can get. So, getting back to the global topic for a minute, is there anything wrong with this commission directing the education director to tell paper and pen providers or paper and pencil providers that the school has to follow the guideline, the rules we have established? Is there anything wrong with that? Because
Absolutely
right
not.
now, apparently, we're not doing that.
No, that he can certainly do that.
And I know you guys had a roundtable to try to figure out how to massage this topic, but what's wrong with just this commission voting to say, tell those guys we're not giving them credit unless they follow the rules we've got established?
There's no problem with sending them the rules. I think the issue that we're running into, which is why we discussed eventually doing the random audit, is that we're not hearing about it unless we get the specific email. And I think of the number of courses that are approved, pencil and paper are less than 10% of active.
Bobby's point, which I tend to agree with. But
another thing that frustrates me is I just out of random, just in my normal work, I had to look up a licensee on something, and I noticed that he got 120 hours for his brokerage to keep his broker's license, and he got 120 hours, and they all got turned in on the exact same day and applied to the Real Estate Commission on the same day, and it's the same school we talked about. Okay, I mean, I'm one of those things. There is a chance that person had been doing this over a long period of time, and they turned it all in at one time. I think it's slight. Okay, I think realistically they paid for all of it, and they got it all done, send it all in, and at one time. I mean, that just smells bad. You know, first of all, the real estate school should have said, hey, there's something not right. Somebody shouldn't be able to get 120 hours in one day. But then again, too, I think that should be a red flag at the Real Estate Commission. I mean, how in the world somebody get 120 hours, just boom? I mean, to me, that should have been a red flag that we be able to see that, too. And it's for all that. You ready for a motion?
You've got the floor. I
Okay,
can't control
then
what you're
I'd like to
doing.
make a motion that we take, because of what D&D has had our meeting, our discussion last month, and what they continue to do even after that discussion. I want to withdraw approval of all their pen and paper classes that have been approved here that are post-license classes. So I'm not looking at their pre-license. I'm looking at their post-licensing classes that they get CE credit for. And effective, make it start March 1. So anybody who has done anything or maybe paid for a class, they got time to finish that class. And when we withdraw approval of them up until the point if they think they can get it corrected or that we're comfortable with them once again. If they can get it corrected and come back to us, we'll talk about it. But that's my motion.
Second.
Okay, so the motion, as I understand it, offered by Mr. Wood, seconded by Ms. Franks, if it passes, would remove all course approvals that deal with pen and paper courses at D&D school related to post-license classes.
And just for clarification purposes, we are removing approval for Rule 1260-05-.10.
Let's say where they have to give 6 written exercises. Is that related to the 6 written
This
exercises?
is just for the withdrawal of approval, which is that's the rule. So it's on page.
Can you read it to
107.
us?
It's on 107 in your book, 1260-05-.10. And I'm assuming, but I don't want to assume, it would be under 1A. Is that correct? The establishment of the conduct of the course violates or fails to meet the requirements of the provisions of this chapter or other applicable law, and that it violates specifically Rule 1260-05-.11 1A 3.
At the written exercises thing?
Yes.
Yeah.
With
those
that.
I
references.
think you mentioned something, and I just wanted to reiterate that just licensees that have already paid for their courses, and maybe have already taken them, that have been submitted, or they're in that middle. Did you mention something about that?
I was saying that I would want this to take effect basically the 1st of March.
So I received 2 emails. I didn't know I'd received them before, but when I received these, I looked at them. January 22nd and February 4th for core law course from this school, and I brought them. But it says, so I think it would be okay because it says you don't pay, call us to pay, or put it on your answer sheet. So you can click and download the materials. But to my interpretation from both of these emails is that you don't pay until you send your answer sheet in. So I don't know that anybody
I'm
will
fine with
be
that.
losing
Right.
anything.
That's good.
Okay, further discussion. I'm going to repeat the motion just so it's clear, at least so that the chair thinks he understands what it is. Motion offered, if approved, would remove course approvals related to printed correspondence courses that are related to post-license courses offered by D&D School effective March 1, 2019. All right, that's the motion in front of us. Further discussion. Ms. Taylor.
Why is it just post-license? Why?
Well, this is my thought. I mean, let's say if you were to purchase a class and it's pre-licensing. Well, we've got a way to tell if you read the material or not. PSI gives an exam.
Yeah, okay.
So that's my thought.
Would you like to further refine the motion to reflect courses of 8 hours or less?
No, I want to stay where we are.
Okay, I'm just checking. All right, ready to vote? Let's do it. If you're in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Could I ask about?
You have the floor.
I hate to come off as Miss Arello again, but in the past, our education director went to every Arello meeting. They have education roundtables. They have different things that just the education directors go to. Now, when Eve Maxwell was our executive director, Steve McDonald went with us on all of those. And then when Steve left and Ross came on, and about that time we had a new director. And so Ross never went on any of these things. I think, there's a good reason that nearly every state is sending their education director to go to the Arello things, because I'm wondering, wouldn't it help Ross to be able to call up somebody in Mississippi and ask them about this instructor? He might learn something that would help him in his job, because is there any continuing education for him on this? I know he's an attorney, but that's separate. I'm just looking if it would help Ross. I think it might be advantageous for him to go. I know it helps Steve McDonald be a better education director.
So I think there's nothing preventing him from going. The deal is they'll allow us to send 4 people. So
and who told you that?
It's a department-wide memo with FNA.
Okay, and so when did that come out? How many years ago?
I think that's been since I've been with the department, which has been at least since 2015. But I think there are opportunities for him to go in the future. And I think, at least from my participation in Arello, it seems like the annual had a lot more education.
There's an education roundtable at every meeting.
Yes. Well, I know I went to the one at the annual, and I found that a lot more beneficial than what was at the spring.
But at the same time, it's going to be the executive director roundtable too, so you're going to need to be at that, so you can't be at both things at
I was
one
able
time.
to go to the education at this past annual.
They're not. Well,
Okay.
They're not this year, at least. I'd like to make a motion, and I don't know, what you can do with it, but I'd like to make a motion as we on the Real Estate Commission that included in travel to Arello would be the executive director, counsel, and our education director, along with 2 members of the commission.
Is there a second to that motion?
Second.
Seconded by Ms. Taylor. You've heard the motion. You've heard the discussion. Any reason to talk about it? If not, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. And Caitlin, I know that you're having to quote a department-wide policy, but if you wouldn't mind, let know the powers that be, whoever that is, that we think it's important to this board that 5 members be allowed to go.
And a lot of the people have changed in Commerce and Union.
So Caitlin, back to your executive director's report, which has seemed to have gone on for quite a while now. Do you have anything else you want to add at this point?
Oh, I know Fontaine might have had a question for me.
We're going to. Oh, about the
center.
telephones.
Oh, yes, yes. I have had several people consistently over my time of appointment, and it keeps being an ongoing issue, is that when they call up here to get an answer to a question or information on something, they don't seem to get it. And there are a lot of people that are falling through the cracks on getting their answers or getting their calls called back or giving wrong information, and I don't know what we can do about that, but certainly something needs to be done. They cannot be given wrong information. They have to be gotten back with, and they have to have an answer to their questions.
Are we still using the service?
Yes, and I would really appreciate it if when you get those, if you would forward the particular name of the person onto me, and then I can actually research their experience. Just telling me that is, I can only, I look at the wait time every day for all the calls, and I look at the response time on emails. So I can control anything that comes through the channel that it's intended to come through, which is the trek.info@tn.gov. Because every one of those emails, they really can't go unresponded to because they stay open. And we are measured on how long an email is open. What I can't control is when they're just emailing who and all these different people. I don't have access to everybody's particular email. I do know, and we monitor pretty closely, the wait time and then the response time on emails.
There isn't so much talking about emails as telephone.
Yes. So telephone, the average wait time fluctuates. Trek roughly gets 1,240 calls a week. So we get a lot of calls. And that's roughly 250 calls a day. So with that many people calling, there is a slight wait time. It ranges from around 3 minutes to 4 minutes, and that's the total average. So obviously, in a high volume time, which we tend to find is around lunch, is one of our higher volume times. It might be a little bit higher, maybe if you call first thing 8 o'clock, it's lower, but that's something that we monitor closely. It also is going to fluctuate around times like right now because, it's not all around the year that we have 3,000 licensees that are without E&O insurance and they just got a letter in the mail. So I think we have seen it fluctuate in January. But that is something that we're consistently watching and looking at. But if you were to get a call from John Smith and he said, "You won't believe I called this many times and I waited this long," and if you sent me John Smith's name, I could look up how many times John Smith had called. I could look up what he was told. I could look up all of those things. And so if you do get somebody like that, if you could send me their name, I can look it up, see what they were told, and then that way I can, if I feel like it wasn't the level of service that we want to provide, then I could address it. I get a report daily, every morning, of the average wait time for the month and how long it's taken us to respond to tickets, and then what each individual staff member's customer service rating is. And so that's something I get every day, and then I get another one every month. So it's not something that I'm not, I'm like, we look at it every day and then on a monthly basis. And I personally am measured on how long our wait time is, how long our response time is, and then what our overall percentage is. So, yes, we can certainly do more training, and particularly in instances where I can see that's not what I would have told that person had I spoken to them.
Bobby.
I just want to speak on that. I had an issue one time that a friend of mine that was getting out of the business, and she said, "Well, I called the real estate commission and they told me this," and I said, "No, you don't have to do this." And she goes, "Well, the real estate commission said that," so I contacted Caitlin, and I said, "Here's her name, here's her license number." A little bit later, Caitlin contacts me back and says she was given wrong information. And here is the date that she talked to us. And would you? And I've gone to that employee. I know who it was that talked to. I've gone to the employee and corrected. Now they have correct information. Would you like for me to contact that person? I said, no, I've handled it. But to me, that was a little spooky. And I've told people now, don't you lie about calling real estate commission. I said, because they know if you really called them or not. And so if that person really, they're saying they're not getting service, they can figure out if they've been talking to somebody or not. So I thought that was pretty good, and I've told people about the timed emails that they're graded on that, and because there have been times I've emailed people, and it'd be after hour, what I thought was after hours, and they responded back to me as I wasn't expecting an answer now, but maybe they were working from home, but they were still getting back to us. So
Yes, yeah. We try, just for everyone's knowledge, to keep an email response to no less than 1 business day. We're not counting people for midnight because nobody's here. But we try to keep it to 1 business day. And then I don't know if I mentioned this, right now the wait time, the average is around 4 minutes.
Jeff?
Well, I just wanted to ask, is the information about contacting Trek also shared with the various real estate associations? Because sometimes licensees will call them, not realizing it's a Trek issue.
Yes, yeah.
Okay.
I don't think there's any lack of people having our phone number or our email, but yes,
and I bring that up because I had reason to go to the association, and of course they know I'm a commissioner. So when they have a complaint about the commission, I have to stay there a little bit longer than I had planned. And she always says, well, when people come and complain about the commission, she's going to have them call me. I was like, what are you going to have them call me for? Like, I can't help them. But, if you have that information at hand of how they can contact Trek directly, that would probably be a better resource for the licensee than to come to me.
Let's talk after. I bet I know who you're talking about. And they do have the contact. I do find people want that personal contact, which I get. The whole reason for kind of the way things have shifted is that licensing folks can focus on getting people processed and out the door, and customer service people can focus on customer service, because I think what we find is if a staff member is getting emails and calls all day, they can't process anybody's license. And I even find that myself, because as my time here has increased, more and more people have my contact information, and it can be hard. It can be a full-time job just responding to people's. There's over 35,000 licensees in the state, so it's a lot of people. Yep.
All right, Caitlin, let's move on. Just one quick question. So you get 250 calls a day. How many people do you have answering those calls?
I don't have the exact number on that for you.
Are they all Trek
No.
designees?
No.
That's
are
why
any of
it's
them
about
Trek?
the service.
Regulatory boards.
Yes.
Yes.
And that's
It's like a 911 operator. If they may not know how to resuscitate someone, but they got it on their computer and they can tell you.
We have one full-time person answering on our staff answering email tickets. That's primarily all she does, is answer emails coming into Trek, and she is with our staff.
so it would be safe to tell
And then
people
we have-
that calls go to a call center and not to Trek.
Yes, there are Trek people also answering the phone, but it's department people as well.
What else on your report? Are you satisfied, first of all, Fontaine? We talked about this enough today. You made your
Satisfied,
point?
yes.
Okay, thank you. Anything else? I think that's it. All right, guys, let's take a 5-minute break. We'll get the legal report immediately following that. So unless there is objection, which I'll try to overcome, there are 2 topics that I'd like to move to the end of the agenda: options to buy and a legislative update, which may actually be a rulemaking update, which we will, unless there is an objection, handle after we do the legal reports. Any objection? Hearing none. Let's move on to the consent agenda. And just because I forget to do this, Just a quick little background for anybody paying attention. We receive dozens of complaints a month, and those complaints don't necessarily go to the Real Estate Commission, they go to the legal department. Maybe short-stopping some of this. The legal department researches the complaints, speaks to the complainant and the respondent when possible, and eventually puts together a narrative to present to this commission that has been, for the most part, is there a word called anonymized? Is that a word?
It's a beautiful word.
So it's a Grecism. So the commission does not know who the complainant is, who the respondent is, what part of the state it occurred in, who the real estate commission, who the real estate company was. It's strictly based on a summary of salient facts as determined by the legal department. The legal department in each case will make a recommendation of how we should handle that complaint, and this commission has the latitude to agree with the legal department and agree with the recommendation, modify it, or totally change it based on our experiences through the years. So we break this up into two parts. One is a consent agenda where legal, in their opinion, has determined the complaint has no merit. That's my take on it, and recommends dismissal of the complaints. So we're going to start with those first. Any commissioner has a right to withdraw any one of those complaints from the consent agenda for further discussion. With that said, once again, I note Kelsey is first. What? So you guys still haven't decided to change it up just to see how it's going to work.
Don't fix what isn't broken.
Well, who said it wasn't broken now? That's legal.
Well, no one said it is broken, so.
All right, Ms. Bridges, let's go with the consent agenda, your portion.
Number 1 is 2018-061871. Number 2 is 2018-062101. Number 3 is 2018-067001. Number 4 is 2018-069511. Number 5 is 2018-068641. Number 6 is 2018-070161. Number 7 is 2018-065491. Number 8, 2018-066821. Number 9, 2018-070991. Number 10, 2018-072321. Number 11, 2018-072421. Number 12, 2018-072251. 13 is 2018-072611. Number 14 is 2018-073001. Number 15 is 2018-074101. 16 is 2018-073241. Number 17 is 2018-073341. 18 is 2018-073401. Number 19 is 2018-074241. 20, 2018-074031. 21 is 2018-074121. 22 is 2018-074441. 23 is 2018-062431. 24 is 2018-040261. Number 25 is 2018-042531. Number 26 is 2018-061221. And number 27 is 2018-077451.
In each case, legal has recommended to this commission that those cases, those complaints 1 through 27, be dismissed. Commissioners, would you like to withdraw any of those from the list? Ms. Hills.
4, 6, and 8.
4, 6, 8. Others, commissioners? Ms. Franks.
3 and 16.
3 and 16. Anybody else? All right, hearing no others, is there a motion to approve courses the council's recommendation on complaints 1 through 27 with the exception of 3, 4, 6, 8, and 16?
So moved.
Second.
Motion by Ms. Hill, second by Mr. Wood, that those complaints be dismissed per council's recommendation. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Marcia Franks, number 3, you had a concern with?
Okay, I'm getting back to it.
I know.
Consent agenda. Okay, on this one, the last paragraph, complainant has alerted local law enforcement authorities and both parties have retained legal counsel in relation to complainant's allegation. And I'm just wondering why we didn't put it in litigation monitoring.
My thought process was that if there was a finding of actual criminal conduct that was subject to discipline or review of their license, the statute does require them to come forward and alert the commission of that conduct. I did not see anything in the complaint file that made me think there's a whole lot to these allegations. So I just wanted to throw in that last line to make clear that there are other authorities looking into it, and if it does wind up being something that this commission should be concerned with, it should come up at a later time.
I just was wondering, my husband is a developer, and I can't imagine telling a company not to come on our property. That's who sells our properties. We want them to come on. So it just feels like to me that something's happening here that I don't know about. And so that gave me pause to be concerned about it, especially if they filed charges against them. Obviously, they showed the property and went on the property. And it makes me think: did they go in the property? Did they go in a house, or did they just walk on a piece of land? Or
I believe they did enter a structure that was either completed or under construction.
Did they have permission to go into it?
Well, so the respondent is saying, I showed my client this property that was on the MLS listing. The complainant is saying, no, I identified the respondent individually and said, you're not allowed to enter any of my properties. However, that notification, or they demanded don't enter, that was sent to a different firm years ago. And there were no limitations on the MLS. So the respondent is saying, I was just doing my job, and the complainant is saying, this is trespass.
Just because it's on MLS does not give anyone permission to go in or own a property. There's a place for you to call the realtor to make an appointment.
I mean, I don't know if they did call to make it up. They just said there were no limitations as to showing the property, so they should, I don't know.
Well, it's called breaking and entering.
In between the posting of the MLS and the showing of the house, I don't know what the exact process was.
So we don't have all the information here, and that's why I'm wondering we're not just doing something other than just dismissing it.
My thought was this: I didn't really think the issue was going in the house. I really think the builder is believing that they were copying the floor plan.
They stole the floor
Maybe
plan.
they were trying to get someone else to build the house.
Mm-hmm.
And so really, that really has nothing to do with the licensee's license. And that's why I didn't think, that's why I thought dismiss was the right way to go about it. I think there's some, you should assume if a builder's got a sign out front, if we walk up to a house that's partially finished and doors are open, a lot of times we just make the assumption it's okay to go see it. But I think this is really an argument about floor plans. I think the going in the property is just a side thing, and that's why I
think that is an assumption, though, that most people would think, developers would prefer you not going in houses like that without some notice of it, at least.
All right, Ms. Franks, you sit on the floor.
I make a motion that we put this one under litigation monitoring.
Is there a second? All right, last call. Is there a second to that motion?
Mm-hmm.
Motion has been properly seconded by Ms. Hills. Now discussion. I have a question for you, Kelsey. Is litigation monitoring usually on civil cases, or do you do that for criminal cases as well?
It could be either or.
Okay, so this is an appropriate motion.
Yes.
Okay. Jeff?
So when we're doing litigation monitoring, what does that then require you to do?
We reach out to the respondent and have them sign a litigation monitoring consent order, which basically says they're agreeing to keep us updated on anything that happens in the case. And if they don't, then that in and of itself would be another violation.
All right, you've heard the motion. Is there any other discussion? Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no.
No.
The motion passes on a 5-1, 1 no vote. Mr. Wood votes no. Number 4, Diane.
Just a question. So this licensee is an affiliate broker and not a firm.
Yes.
So, but they must have their license with a firm.
Yes.
So one of the main complaints, or maybe the only main complaint, is that the complainant states that the firm is not with the Secretary of State to conduct business in Tennessee.
And that may be true.
Because so when I got the firm license, I had to show and prove, and I had to wait for the Secretary of State to say the name I'm doing isn't similar to somebody else's. And then didn't I have to send that in when I got the firm license?
That's a possibility. I'll defer to Caitlin on whether or not that's required for a firm license. But in this case, I'll just say that there are a number of reasons why a Secretary of State registration may be temporarily or permanently dissolved. A lot of times it's an administrative dissolution, which means it's kind of more like a suspension. You just have to file the right documents.
So we just allow the firm to keep a license if they're not.
Well, the Secretary of State isn't going to alert us if a business is short on their filings, or if they miss the deadline for their filings.
Because I have to file an annual report,
right?
And I have to send money, and all it says is, I'm still here, and it costs me $325 or $350 to send it in by a certain time and say I'm still here.
And if you didn't do that, I think within 3 months, the Secretary of State is going to have your entity administratively dissolved until such time as you submit the proper documentation.
But we don't care? That's
I'm not
my
saying
question.
that we don't care. I'm just saying that I think that's kind of a separate issue. Now, it is for the commission to say if we care or not. I won't say we don't care.
To start, you would think we would have to have it to keep it. Yeah, that's just my reasoning.
So I need to pull up the rules. We do get that upon initial licensure. It does not specifically state we need the business license. Let me pull up.
Because I had to get I had to send in an original, or I think I had to send money to the state to have a certified original one to start the firm. So I guess that's just my question, why we wouldn't care. Well, but mine hadn't been that long. Mine's only been like 5 years. And I just paid for my annual report. I just wrote that check.
So let's say that's a non-issue. Kelsey, is the fact that this respondent has an expired license, did that come into play at all?
No, you saying expired with regard to their business registration?
No.
No. November 3rd, 2018. That was my next.
Oh, I'm sorry. I didn't jump.
No, I'm glad.
Which
We have a license that's
Number 4.
expired. In the header of that part.
We're on number 4, right?
4, yes.
Okay. And I'm sorry, where's the...
It says expires November 3rd, 2018. And they could have renewed by the time.
Michelle Casey.
I need to double check that. I don't know why it's saying that.
Why don't we come back to that?
We need somebody to stay on license verified all times. It seems that comes up every other thing.
We can come back to
Kelsey, I'm
number
going to
4.
slide on number 4. Let's
We
go.
don't know the name to look it up in license verified. if they
Yeah,
do.
we can't do it. Let's go to number 6, Kelsey. We'll give you time to get that. Diane, you also pulled this one.
Let's see. Oh.
This is a complaint where it appears that the licensee, the respondent, had two different addendums prepared.
Yes.
One of them that was specific as to when the home inspection had to be completed, and one of them that was open-ended.
Yes.
And it appears to me that he or she had both addenda signed.
Yes, I think it's just the one addendum to the purchase and sale agreement, but more or less your summary was correct. The purchase and sale agreement provided for a 10-day inspection period, whereas the addendum, which was signed in conjunction with the PSA, provided for an indefinite inspection period. And again, while I would counsel using such a clause, I don't know that contractually that holds up. I don't think the clause in and of itself is violative of
They
our
were
act.
signed on the same day?
Same day, one after the other.
Well, it might be my opinion that this is pretty sloppy work or deception, one of those two, neither of which I think should be dismissed.
I would lean towards sloppy work. I think it would be hard to prove that there was an ill intent just based upon the fact that everything was pretty clearly laid out in the contracts. Again, do I think it's a good idea to use a clause like that? No. But is it, I don't know that bad ideas are necessarily covered in the act.
Do you think it's a good idea to have conflicting language in two different parts of a contract?
Well, the addendum would the addendum, and most do, it does contain a clause that says if anything in this document is contradicts any other documents that have been signed, what's in here will control. Now, that's pretty typical of every contract. So by signing that, they said, forget everything else I've signed. This is going to be the controlling document.
So the licensee should have known that. The seller who doesn't, you don't tell me that they're licensee, so that seller would know that information.
Mm-hmm.
And the respondent's the one that had the two addendums anyhow. So it looks like
contract class may be good. Bobby.
My thought is this. I would agree with the point that if you put it in writing in an amendment or an addendum or something, it's changing what was pre-printed in other part of the contract. And maybe the seller didn't have the ability maybe to understand that, but they did have the opportunity to hire counsel or to hire representation, but they chose not to. And so maybe they were their own worst enemy by not getting help. And so I don't think it's fair to come back after the fact and say, I screwed up.
But they still left it open-ended where, do you like at your office, your agents, to have an open-ended, no closing date contracts?
Well, I think...
Is it really a contract?
I think the buyer, they were writing for their benefit. And they out-negotiated the other side.
I'd also like to point out a confirmation of agency was executed. So I think that would have been the seller's opportunity to realize, I'm not represented. Maybe I ought to be, but I'm going to sign off on saying I'll do this on my own.
All right, Bobby, why don't you make a motion? Let's see how it goes.
I'll make the motion that we accept council's recommendation to dismiss.
Is there a second?
Second.
The motion on the floor properly made. We'll dismiss this complaint if it passes. Further discussion. If you're in favor of that motion, vote aye.
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 If you're opposed, vote no.
No.
The motion passes on a 4-aye. The chair voted aye. 2 no votes. The 2 no votes were Diane and Fontaine.
3 no votes.
3 no votes?
Mm-hmm.
Oh, if there are 3 no votes, then the motion fails. My fault. Let's back up. Let's take a roll call just to be clear on this.
Commissioner Jeff Diaz,
Votes aye.
Commissioner Marcia Franks,
No.
Commissioner Diane Hills,
No.
Commissioner Fontaine Taylor,
No.
Commissioner Bobby Wood,
Yes.
Chairman John Grease.
Yes, the motion fails. On a 3-3 vote, the chair is now entertaining a new motion.
Right, so what's the charge if someone's,
What
They're
about
like
a
their
contract class?
but what's the charge?
Reasonable skill and care.
Reasonable skill and care.
Yeah.
That's it.
That's a nice discussion, but
Oh,
somebody make a
uh-oh.
motion.
I would like for us to find in number 6, a failure to use skill and care. And with that, how many hours is contracts? Is it all 4? 4-hour contracts class and a $250 civil penalty.
Second.
All right, the motion properly made and seconded, if passed, will offer a consent agreement to this respondent that would include requirement to take a 4-hour contracts course within 6 months, in addition to other education he or she may have to take, and a $250 civil penalty. Discussion. I hear none. Let's vote. If you're in favor of that motion, vote aye.
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 If you're opposed, vote no. Motion passes unanimously, 6-0. All right, number 8, Diane.
Main question is this affiliate broker licensed right now?
So right now, they're suspended because of the lapse in E&O coverage.
We're going to open that separately, right?
Just wanted to confirm in my mind that it was still, yeah. Motion to approve number 8, take council's recommendation.
All right, the motion made by Ms. Hills and seconded by Mr. Wood will, if it passes, dismiss this complaint per council's recommendation. Let's vote. If you're in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Ms. Franks, number 16.
My question is, the statute of limitation, is that the same on every real estate matter, and what is it?
Well, yes, actually it is. It is 2 years from the date that the violation occurred, or 2 years from the date that the aggrieved party discovered the violation occurred.
Okay, so they closed on 2015. When did they discover? I know they discovered when it backed up in the tub, and they realized something's not right.
Yeah, and I realized as soon as you called that I didn't say when the claim was discovered. When I was writing it up, I did take note that this was definitely outside the statute, but that's something I can pull up the information on and get back to you with.
So I'll make a motion that we defer that one until she gets the information. Is that something you can do today?
It should be in the complaint file.
Okay.
Okay, Kelsey, we're leaving you with number 4 and number 16 to finish up, correct? Yes. Make sure we're both. That will do without objection. I just want to make sure that that's what you think your charge is at the moment, 4 and 16.
Yes.
4 detail. Okay. All right, Erica, would you read in the record the consent cases you're handling?
Yes. 28, 2018 061 361. 29, 2018 063 181. 30, 2018 064 081. 31, 2018 064 141. 32, 2018 085 301. 33, 2018 064 391. 34, 2018 064 461. 35, 2018 064 701. 36, 2018 065 971. 37, 2018 066 941. 38, 2018 067 201. 39, 2018 067 561. 40, 2018 065 601. 41, 2018 073 221. 42, 2018 069 811. 43, 2018 069 391. 44, 2018 069 681. 45, 2018 069 911. 46, 2018 067 491. 47, 2018, 070531. 48, 2018, 071371. 49, 2018, 071491. 50, 2018, 072151. 51, 2018, 072351.
Thank you. Commissioners, any cases in that batch you'd like to pull out? Ms. Hills?
Number 28, 45, and 46.
Other commissioners?
About 30, 33, 35, 41, 42.
Anyone else? All right. Hearing nothing, no other request to pull cases, is there a motion to approve council's recommendations related to cases 28 through 51 with the exceptions of 28, 30, 33, 35, 41, 42, 45, and 46?
I move.
Motion by Ms. Hill, seconded by Ms. Taylor. The motion is to approve the balance of the cases and to approve council's recommendation. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 28, Diane.
So this is an unlicensed activity, and 1, 2, 3, 4, about 5 or 6 from the bottom of the first of the page, not the first paragraph. Well, let me just read it. It says, trying to avoid being disciplined for the 6th time for the same advertising violations he has been publicly disciplined for by the commission in a few years. So I guess is somebody not getting number 28? 1, 2, 3, 4, 5. About 5 rows down.
Yes.
So is that saying we've had complaints about this unlicensed activity, and then it keeps coming back?
Only against the broker that hired this this respondent who lives in the Philippines and was just sending some emails.
Okay.
So and we presented the complaint against the broker last month, and we downgraded that broker from principal to affiliate.
Okay.
So we have
seemed familiar, but then it confused me.
We had this on that report, and for some reason, I think maybe the name was there, and we took it off at the last minute.
Oh,
so it was just an administrative error that it's here.
All right, I'm okay with it. Motion to approve council's recommendation.
Second.
Motion by Ms. Hill, seconded by Ms. Franks, that council's recommendation be adopted on number 28 and this complaint be dismissed. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Erica, a quick follow-up on that.
Yes.
So you offered a downgrade to a licensee. Did they accept it? Or is it still out there?
They still have time. They have not accepted it yet.
So you're not, just to be clear, you're not representing that it's been accepted?
Correct.
Okay.
It's only been offered. Yes.
Got it. That's what I want to make sure of. All right, number 30, Bobby.
I think this was the one where they were buying a new home, their rate lock expired, and then the question became who was going to pay for the rate lock.
Correct.
And then, I'm trying to reread this. Did the agent say he was going to do it, but then he said he was going to do it and pay it by gift cards, or is that something that the complainant said the respondent was going to do?
The complainant alleged that the respondent said they were going to pay for that, and the respondent denying that. The respondent seemed to state in their response that they wanted to try to help compensate the complainant, but there was no evidence that they ever said that they would in that way.
Okay.
Or in any kind of illegal or a way that would be a violation.
No inducement.
Okay. Then I'll move to dismiss.
Second.
Motion by Mr. Wood, second by Ms. Hills. This complaint be dismissed. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 33. Bobby.
This was about a septic system,
Yes,
I
my
think.
favorite.
Let's see. I'm trying to remember what I had a problem with.
They paid additional earnest money after they were made aware of the issue.
Were they advertising that it had a 5-bedroom, but it only had a 3-bedroom septic system?
They were advertising that it was a 5-bedroom home, and the property is in a county with no building codes. I don't know if that means much.
No, that really doesn't mean anything because even the septic system is a state issue.
Okay.
I mean, so it's really
not a
the
county.
state. No. So the state has to. In real life, what happens a lot of times, you get these things done and then they lose the permits, and they can't find how many bedrooms it is. But apparently, somebody found it and knew that it was 3 bedrooms.
Right. So I guess after the contract was signed, it was discovered that the septic system was installed only to support a 3-bedroom home. And the respondent's argument is that the seller and the listing agent, neither of them knew about it until the local groundwater protection office gave them notice.
We had a case similar to this, Bobby, when I first came on, and I live in Williamson County, and I'm like, what do you mean they don't have codes? Wendell Alexander, who was from Dresden, Tennessee, said we don't have codes. And so the problem becomes, we know codes to be a bedroom is a window and a closet, but it's not in Dresden. You could call anything a room. And so when I read this, I thought that's what has happened here again. You could call any room, a bedroom in the MLS.
But see, if you have knowledge, so now these people have knowledge that it's 3 bedrooms.
Mm-hmm.
So they go to sell it, and it was advertised as a 5-bedroom. Well, now they have knowledge; they can advertise it as a 3-bedroom. I don't care how many windows, egress, and out. So it's 3 bedrooms. If my memory, and I'd have to skim it, they decided not to close because that did change it. They've not. I mean, in my opinion, but they were saying they couldn't get their earnest money back. So it's like sort of like an adverse fact because it.
That the seller
once
didn't
it was
disclose.
discovered, and when you go to apply for a number of bedrooms, it costs you money. Each bedroom requires more lines to put it in, and then it costs more for that application.
My thought is it was just some negligence on the listing agent's part. They should have looked this up maybe at the time they got the listing, and they didn't do that. They waited till they got a contract. So.
That's a serious thing you need to know, sewer or septic.
Yeah. Mm-hmm. Yeah. And then how many bedrooms it's for. So I want to make a motion that we have a $500 civil penalty from the for the respondent for negligence.
So not using reasonable skill and care.
Thank you.
401.
Thank you.
Is there any class?
It's a firm.
I'd like for them to have.
The
Oh, it's a
response
firm.
Okay.
Well, so the
Because they're
complainant filed
holding the
charges
money.
against the firm, not the
Because-
person?
Yeah.
Because that firm, because they didn't get their $5,000 money back.
You're right, that's why.
All right, there's a motion on the floor. There's no second to that motion. Does anyone care to second that
I'll
motion?
second it.
All right, Ms. Frank seconds the motion. If passed, the firm will be offered a civil penalty of $500.
So is this reasonable skill again, or?
Yes. It's
Okay.
what's Erica saying?
Is there discussion on the motion? Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously, which brings us now to number 35, Bobby.
Let's see. Oh, I think this was the issue where the respondent, the listing agent, had gone back and modified the contract after we had if they had an agreement, where they changed it to something said by buyer when it talked about, and they made it to say
Closing
buyer
costs.
to pay all closing costs for buyer and seller. But they modified the agreement after well, after it had been an agreement. That was my issue. Am I misunderstanding that?
And did you have a copy of before and after?
From my recollection, the language was added because it was agreed upon by both parties and then signed. I'd have to go back and look if I have a copy of both.
Okay, I didn't get the impression. I thought the complaint was because maybe it wasn't everybody didn't sign it, but maybe I misunderstood.
I think the complaint is that the complaint is saying that no, we never agreed to this language, but I have the signed document that shows that they agreed to it when they signed it.
Well, would you mind just looking and just make sure if everybody? I mean, I don't mind that they wrote it. If both sides have initialed it, let's say, or signed it, I'm good. Okay, but if not, then I got a different answer.
All right, let's come back to
Yes.
it, Eric.
Yes.
We'll take
The before
35
and
off the
after.
table for a minute. Let's go to number 41, Bobby.
Start making better notes when I'm looking at these at night.
Did they respond? Did the respondent respond on number 45? I was not clear.
41.
41. Oh, sorry.
Oh, yes, the respondent, on 41, the respondent responded through an attorney they hired.
I was looking at the wrong one. Oh, this is
okay.
I wonder if they held back adverse fact.
Okay, yeah, I think this is the one where did they buy the property and that they had a renter, but they didn't disclose that the renter hadn't been paying rent for
Yes,
a long period of
that's
time.
it.
Yeah, and because I think that would have mattered to the value of the property to the potential buyer.
Because it leaves the new owner.
Now they got a victim.
It can't get them out.
They'd rather have it vacant
the
than.
previous owner hadn't been able to get them
Yeah.
out for a year.
I know that the rent history was provided June 22nd. Let's see. The listing agent, the listing agent had asked the tenant to submit reasons why they were delinquent June 7th and then submitted all of those reasons to the complainant, the buyer, June 22nd.
And this new owner wanted that money. So when the new owner's wife went over there and knocked on the door,
yeah.
that's when
Yeah.
money appeared. And so the old owner kept the money.
Correct.
And the
Because
new
it was
owner
all
didn't-
delinquent fees
Yeah.
related to the person who owned the
But
property.
who triggered it was the new owner's wife.
Right.
Going to sell that way.
Yeah.
I'm remembering it. Well, I think that information had been held back.
I think that's a reasonable skill and care issue again. I mean, I think they didn't provide that information because they didn't want to do anything to hurt the possibility of a sale.
Right.
So here's why I'm not sympathetic to the buyer. It's me, but the buyer is a licensed agent who, by that alone, should have more knowledge than a typical buyer. This is a multifamily property. A buyer with any skill should have asked for, at the very least, some sort of estoppel to be signed representing
Right.
what the situation was for the tenants. The buyer apparently didn't do any of that. I don't get the sense they cared too much about it until after the fact. I don't have strong feelings that way, but you tell me you're a licensed agent buying a house, I think you've got more knowledge than the average consumer does. This is a multifamily property or a commercial property, I'm not sure which.
Multi, I would say.
Multifamily.
Yeah.
But there should be an estoppel on
So-
anything like
There should be an
that.
estoppel for sure, but,
So, I mean,
and don't you talk about all the time how much education Texas agents get?
I was going to say in Texas. So the information about the late rent, which was extremely late, was not given until after the property was purchased.
Well, so the buyer went ahead and decided to close without,
Yes, they did. And then they asked for it, and it was given to them. they wanted to stay with the property management firm too, as well.
Okay,
So I don't.
that's all right. Anyhow, did you have a motion on the floor, Bobby?
Dang, I'm seeing your side now, John.
I know. That's how I like talking
Because
about it.
I mean,
I agree.
they should have known better. I mean, unless they just maybe weren't figuring in this money at all, and they're coming up with their, otherwise they would have said, "Let me see some leases, let me see some rent roll. I mean, let me see some things here."
Texas requires 240 hours
Well, because my
of
impression
education, where
is,
we I have 16. They do 240.
my impression is that the buyer was willing to go forward. It was only after money came in, after he owned it, that he didn't get the money. The seller got the money. To me, that was the whole
Like it was
grasp.
back rent.
Right, and they're
uh-huh.
and the complainant's saying we want to be reimbursed for the travel that my wife did having to come down there. That's basically what they want from us.
I'll make a motion. We accept council's recommendation to dismiss.
Second.
Motion by Mr. Wood, seconded by Mr. Diaz. If passed, we'll accept council's recommendation, and this complaint will be dismissed. Further
And can we
discussion?
also? I think 42 goes along with it too, doesn't it?
Yes, yes.
Okay, so can we
And
make
43,
it,
yes.
Yeah. Can we make it for all those
Yeah,
then?
41 and 42 are combined at this point.
Yes.
The motion covers both, and both will be dismissed if they pass.
And 43.
That's not,
I think we already got that.
We've already handled that one.
Yeah.
Okay, yes.
All right, let's vote. If you're in favor of the motion to dismiss 41 and 42, you'll vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. Diane, we're to 45.
So did the respondent respond?
For 45.
Yes, because it just.
Oh,
'cause it
yes.
just says some facts that
They-
listed the property. I didn't.
The respondent did respond, and I didn't include the summary. Just I think
Okay.
I felt like it was. If you wanted to talk about it, we can.
No,
but they did.
I'm okay. I just wanted to be sure they responded.
Yes.
Motion to accept council's recommendation.
Second.
Motion by Ms. Hill, seconded by Mr. Diaz. The council's recommendation be adopted and complaint number 45 be dismissed. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 46, Diane.
I'm trying to recall. So the respondent is unlicensed, short-term rental. So the second page, second row down, respondent has failed to show proof that hosts living in these communities have the authority to engage in short-term rentals prior to. So.
Or I should
that
say the complainant
confused me.
alleges that. I'm sorry. The complainant alleges the respondent fails to show proof.
Did you see any proof?
Well, I didn't see any proof from the complainant side. I saw a very, very solid argument from the respondent side. An argument that I feel like they went into great detail for having absolutely no evidence or proof from the complainant side. And I have the argument. I can summarize it for you if you like.
Oh, that's
no.
okay.
Okay.
I just wanted to be sure you had enough.
Oh, yes, I have.
Motion to accept council's recommendation.
Second.
Motion by Ms. Hill, seconded by Mr. Wood, and if passed, we'll accept council's recommendation and this complaint will be dismissed. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Erica, we're leaving you with number 35 for a little more research. Kelsey, we're going back to you if you're ready for number 4.
Sure. So on number 4, what we found out is that that affiliate broker is actively licensed currently. It looks like the reason why there was some confusion there is because the complaint was filed around the same time as the individual was supposed to renew. They have renewed. They are active. Additionally, we were looking into the firm requirements for licensure, and it doesn't appear that having a Secretary of State registration is actually a requirement.
So when we get you start, I send in for a new firm, ABC Realty here. I don't have to have that.
I don't believe so. I just looked
Okay.
up the paper application, and it does not mention having the SOS registration. You do have to turn in articles of incorporation, which is something that the Secretary of State is also going to require, but turning in that actual registration is not required.
And think that's why we get it a lot, is because from that, if they're registered with the Secretary of State and they are registered as a certain type of business and it's already been approved, we can tell that from that.
Hills, you have a motion on
So,
number 4.
so do we know if this is, if this firm then is,
They're active now.
Okay.
Their new expiration date is 11/3/2020.
but current with the Secretary of State?
So that's not required for renewal, for them to resend us anything from the Secretary of State's office. So,
Once we do it the first time, we do not have to keep it current. That's my question.
well, that might, you might.
State of Tennessee might want you to.
It's a different
Yeah.
issue, especially if that entity owns something they need to sell at some future date. It needs to be an active entity for that to happen.
Like the
Not
business.
administratively dissolved, which I see a lot of.
REC is not requiring firms to resubmit that each renewal.
Thank
So
you.
your motion-
Motion to accept council's recommendation.
All right.
Second.
The motion by Ms. Hill, seconded by Ms. Franks, is to accept council's recommendation and dismiss this complaint. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. And number 16, Kelsey.
On number 16, I was basing that statute of limitations lapse on the fact that there was, now I don't know their actual possession date, I don't know the day they moved in, but there was an inspection, there was an appraisal, every disclaimer imaginable was signed, including the standard disclaimer on the MLS, the one that says, information believed to be true but not always deemed reliable. I can't imagine in any world where a person would have gone through all of those inspections and appraisals and no one would have mentioned this is on a septic tank. Now, that being said, I don't know the date of possession, so I guess it is feasible that they could have done all of this and decided to move in three years later. I think that's unlikely.
Oh, but see, the discovery's going to be when it fails. I mean, I just read off or
And it was not
on something
closing day
that the
ever.
licensee had it as sewer.
And this was
And
a fixer-upper purchase as well, if that is relevant to you all. It wasn't,
Well, he had mine that an inspection was done yesterday, sewer, and I had the buyer, sewer, and 5 bedrooms. And before I wrote the offer, I discovered it's septic, and it's approved, and I have the documentation that's 3 bedrooms.
What did the Tennessee
So-
property disclosure form show?
It was exemption.
It was an exemption form.
And mine was an exemption too.
It was on.
So
the
it wasn't revealed to them.
Excuse me?
It wasn't revealed to them if there was no property disclosure.
But there was an inspection and an appraisal.
Yeah, with the I don't.
You don't
none
have
of
an
our
home
inspections.
inspection.
No.
I mean, your
would not-
septic
You
inspected.
can call our city, and I'll say, "Can you tell me it's hooked up?" They say it's being charged. Sewer's being charged.
That's
I said,
different.
"That's not my question. Is it hooked up?" Well, we'd have to do the dye test. You have to pay the money and do the dye test and apply for that.
And while we're getting into the particulars, I'll go ahead and mention the reason why the respondent created this MLS listing saying they believed the property was connected to the sewer was because the individual who had been living in the property prior to its foreclosure, it looks like they were the victim of some sort of scam or fraud because they had been paying sewer bills
Well,
for
this-
years. So
yeah,
That can happen.
that happens.
Oh, yeah, that happens.
That
It's not fraud, it's just.
It never got hooked up.
And so relying on this owner who didn't know, they were going off of that owner's belief
Still
that it
reasonable
was
skill and
connected.
care
So
problem.
it was a foreclosed property. I think that they created the listing with the information they had.
All right. We hear your justification. Let's see what this commission thinks. Diane?
Well, I don't think I was the one that added this.
I think it was me, wasn't
Yeah,
it?
it was Marcia.
Well,
May
but
I?
you had the floor. That's why I
Oh.
was going to you. You were the one who was going on about all this stuff.
Because we have septic.
But if you want to yield the floor, I'll go to Marshall.
Yeah, go to Marcia. It is a problem.
I would like to find that this licensee did not use reasonable skill and care, and charge them $500.
Offer them a civil penalty of $500.
Yes.
Is there a second to Ms. Frank's motion? Seconded by Ms. Taylor. Discussion on that motion.
So, but the home inspector didn't catch it, and is that right? And the appraiser didn't catch it.
Yeah, in our area, I think either one of those would have caught it either.
Then why should we hold the agent out to catch it? Because what access could they have done?
Just in this little piece of paper, it's like Form 702 or 1 or 4.
You can make
to
a
the
call.
environmental, and then the environmental says there's no records found, or here are the records.
But it was, it did have a disclaimer because they didn't ever live there, so I think, yeah.
They were paying a sewer bill, and I think a lot of people make that assumption that that means you're hooked to it. It just means you're paying a sewer bill.
Sewer bills can be for 15 different things rather
Well,
than
you know,
sewer, yeah.
municipalities years ago, they'd say, we're going to put the sewer in,
Mm-hmm.
and you got to hook up in the next 10 years. Not now, but or whenever you go to sell a property, and people forget, and then they just start billing them. So that's why I would still say dismiss. I don't know why the agent is held to that big of a standard if nobody else caught it. No of the other professionals caught it.
Other discussion? All right, the motion, if passed, will offer this licensee, this respondent, a $500 civil penalty.
Well, I'd like to withdraw my motion.
Dang it, I was just getting ready to vote on this.
I would like to withdraw my motion, and my motion now is that we dismiss it.
Dang, but good job, Bobby. All right, the motion now on the floor,
You're right.
if passed, will accept council's recommendation. This complaint will be dismissed. Further discussion?
Did we hear a second on that, Mr. Chairman?
We did hear a second.
Okay.
I think it was you, wasn't it, Jeff?
I seconded
No,
it.
sir.
Marshall's
Oh, it was
motion.
that Fontaine.
I know our voices are similar, but
Well,
Well, we looked-
and all I get is a silhouette off that window, too. All right, the motion is to dismiss. Been properly seconded. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, vote no. The motion passes unanimously. Now, Erica, we're back to you.
Yes,
Number
yes.
35.
So I do have the copy of the offer that came from the complainant that originally just had the words "by buyer," and that was not signed by the seller. And then I have the next version, which had the by buyer or buyer to pay all closing costs for buyer and seller, which was signed by both parties. And then it ends up that ended up coming out, and it went back to by buyer, and that was signed by all parties. So it went back to the way the complainant wanted it in the first place.
Signed or initialed?
Signed, yeah. There was a full new PSA for all of them.
Do you feel stronger than ever your recommendation is correct?
Absolutely.
Just checking.
Then I'll make the motion we dismiss.
Second?
Motion by Mr. Wood, second by Ms. Franks, that this complaint be dismissed per council's recommendation. Further discussion? Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. That completes the consent agenda. Before we go to the legal report, one of you two attorneys used the letters SOL, which I've always
Statute of
associated with
limitations.
something differently than statute of limitations. And so,
What did you think it was?
well, I'll have to
Can't
tell
say
you
it on the
after
record.
we're off the.
Oh, no. It was Kelsey.
And I just wanted to make sure I understood correctly what that was.
I just got it. I'm so slow. Statute of
I don't know how
limitations.
y'all all knew that.
You did it.
because we've said it.
You people from downtown Franklin don't talk like that.
No, we do not.
Oh, here, he'll do it.
About.
All right, we're going to the legal report. These are cases that have been presented to council, and council thinks dismissal is not necessarily the right way to go on it. Ms. Bridges, let's get started.
You've said it.
For number one, this is, again, a situation that the commission has been made aware of, this ongoing timeshare fraud scheme. So we have another one that we'd like to recommend for litigation monitoring, and that is number 2018-065731.
Oh, for people watching this who haven't watched last month, the scam is what? Can you define the scam?
Yeah, so we have a situation where it could be multiple entities, but it could also just be the one. It looks like they are operating outside of Tennessee and most likely outside of the country. And they're creating, sometimes they're referred to as cloud companies, where it's just a website and they're stealing the information of actual licensees and putting that on their websites. They, you know, by your average person's account, they look pretty legitimate. So when these companies contact individuals, they think they're acting with an actual licensee, and unfortunately, that often results in a loss of finances to the consumer.
The consumer is harmed, and licensees
Is also
are being
harmed.
accused of hurting the consumer.
Yes, and actually, we'll see one and a few when we get to it that I've put up for a represent, and it actually comes from one of these licensees that has been harmed.
So council's recommendation is to place case number one or complaint number one in litigation monitoring.
Move to accept council's recommendation.
Second.
Motion by Mr. Wood, second by Ms. Hills, that council's recommendation be adopted. Discussion.
So there is litigation that is going on now through the
Well-
Attorney General's office?
No, there's not actual litigation. That's just kind of a procedural thing where we don't have any other way to put these matters on hold, quote unquote.
Did you have any wording that had to do with IDX anywhere in it? Internet Data Exchange? We do that through our MLSs.
I don't know. I'm not sure how to answer that. I've never seen IDX.
It's on my website. You can look at every listing within RealTrax. They're not all my listings, but I have IDX so that can show up on my site.
I think we might be talking about two different things. In
What are
this
we talking
case, it's not exactly listings that are being created, it's just fake companies.
Motion is to accept council's recommendation. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Just out of curiosity, Kelsey, how many agencies are we talking? How many aggrieved parties at this point? Dozens, hundreds, two? Could you just generalize?
Well, that we know about, couple dozen.
We probably only received roughly like 6 complaints, though, on this. Do you think it was more than that?
Yeah. Yeah.
Yeah, it seems like the first time we had about 6 on the first report.
All right,
It's a lot.
forget that question. Let's go to number 2.
Okay, number 2 is 2018-047011. Complainant is a property owner and the former client of respondent, a licensed real estate firm and property management company. Complainant alleges respondent has failed to remit monies owed to complainant under the terms of the parties' property management agreement. Counsel requested an investigation to produce financial records relevant to the complaint. The investigator reported back that respondent's retail office space is vacant, and according to the owner of the firm, they are no longer operational. The owner further refused to supply the investigator with the documents requested. My recommendation is for revocation based upon respondent's refusal to produce the requested information pursuant to Tennessee Code Annotated 6213-312D.
Move to accept council's recommendation.
Second.
This motion by Ms. Frank, seconded by Ms. Taylor, if passed, will revoke the real estate firm's license. Ms. Hills.
So are there licensees under this firm?
Just one individual who is the subject of the next complaint, number 3.
Okay.
The principal broker.
All right.
right,
Just want
other
to be sure there were no others.
But y'all did
Okay.
talk to the owner, and he just said, I'm not going to.
The owner is the principal broker, and they
Okay.
said,
We're getting
I mean,
there.
they said, we already gave you what you wanted, which was not true. They requested more information. They tried tracking them down for weeks, and they refused to cooperate.
All right, the motion is to accept council's recommendation and revoke the firm license. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. And for the record, again, these are, if we pass these recommendations, then legal goes to the licensee and says, here's what we'll agree to. And they have to agree to it themselves before that revocation actually occurs.
True, yes.
Just make sure. Let's get to the principal broker.
Okay, number 3 is 2018-047071. Respondent is the individual owner of the property management / real estate firm above and is also individually licensed as a principal broker. However, respondent's license is currently suspended due to a lapse in errors and omissions insurance coverage. And again, my recommendation is for revocation based upon respondent's refusal to produce the requested information pursuant to Tennessee Code Annotated 6213-312D.
Move to accept council's recommendation.
Motion by Ms. Frank, second by Ms. Taylor to accept council's recommendation and offer the licensee the opportunity to have his license or her license revoked. Let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. Now, Caitlin, I just have a question. So this is only an offer. It's not revoked until he agrees to it or until we have a formal hearing where we may do that. Since his firm license has been revoked, can this licensee place his license somewhere else at this point?
I mean, I think there's somewhat of a short window for them to do that once their status changes.
Status hadn't changed until they agree to it. So this guy could bounce around, it seems like to me, or this lady, for a period of time.
So could we make some sort of motion that that not be allowed? That they not move it?
They are currently suspended, so, until, they would
flag it
have
right
to
there.
rectify the suspension before they were able to before anything else was able to be approved.
Just errors and omission suspension. I mean, he could send that in today, or she, and have that done.
I mean, they could theoretically, officially, we could have a motion to flag the individual respondent's license to make sure that doesn't happen. I will say, more often than not, these respondents don't sign the consent orders with us asking for revocation. So in theory, yes, they could reapply, but I don't think there's any way that license would make it past the application stage, just given the severity of the situation.
And I'd like to make that motion then.
Let me just make sure I'm clear on this. So if this licensee tomorrow, since his firm license may not be in effect, wants to go to ABC Realty, there's nothing that will keep the staff from allowing that to happen at this moment. Pardon me? He'd have to get his errors and omissions insurance paid, and because we've offered him a consent agreement to revoke his license, has nothing to do with whether he can move it to another place at the moment.
Well, that's a hole in the boat that needs to be plugged on anything that we do.
Flag it.
Well, so we flag it. What does that do?
Well, it notifies us that they, currently have a consent order out for revocation.
If he gets an attorney and says, I've paid my errors and omissions, I've not agreed to a consent order, I want to move my license to this firm, I don't know that you have any choice but to let him do it.
Yeah, I think this is a situation where they can run, but they can't really hide because we have this revocation out there. So if they elect not to sign the consent agenda, then you would be seeing them via a formal hearing. And if they don't show up to the formal hearing, then...
But she's going to get paperwork, she's going to get the TREC form that they have moved to another company. So if it's flagged, when that comes in that they've moved to another company, then she could tell the principal broker, I'm sorry, but that person has a revocation pending.
Proposal. It's all this is a proposal.
We're not proposing it, we're revoking it.
It's proposed, that party has to agree to accept it.
Right. Right.
And if that party doesn't, they can have a formal hearing, which could drag out for a year.
I sure would
frankly.
want to know that as a principal broker, though.
I got it, but I'm just trying to see why this person who has not been cooperative at all couldn't just put his license or her license somewhere else. Pay the E&O, get that out of the way, until that revocation is final, which could be months.
Well, I made a
Person that's
motion to
right.
flag it at least so that we can, if we have to bring it up again next month that they've done that, then we need to talk about it again. And there should be some, if they don't respond, that's failure to respond again. If they're unlicensed, it doesn't matter.
Yes, Jeff.
Are we able to have a second cause for the license to be suspended aside from E&O? Can we suspend their license pending the results of the consent order?
That's what I'm trying to look up now, if there's any way that we could just summarily suspend them, which is essentially what's happened with the E&O insurance. But I think what you're saying is if they get that corrected, can we still just have them be suspended? We're trying to find an answer to that question right now. I don't know if there is a way to do that without due process, though.
Well,
not for the failure to respond. None of that. We don't.
Well, that's what I'm recommending the revocation based upon, is that we requested financial records. They didn't give it to us. Therefore, I'm recommending the revocation. So, yeah. To summarize, I'm not sure, but we're going to look into that.
So do we need to hold back on?
I think
Defer
a person may be able to make the case that this licensee absconded with someone else's money and can be considered a threat to the public. And in that type of situation, we do have an opportunity to ask for a quick, what's that term called?
Summary suspension.
Summary suspension.
Which you can do on top of, I would think, on top of an E&O suspension. Even if they deal with that issue, they're still summarily suspended.
Do you know pursuant to what authority in the statute that would be?
No, I don't know the citation.
Yeah, that's what we're trying to find, is where's the authority for summary suspension. We're not sure if it's actually in the statute.
No, I'm positive that it is. I just don't know.
Why don't we defer this and let's move on, and you guys think about it for a little bit.
Let's bring it back up today, though.
Yeah, it's going to happen today. We're going to have to take some sort of action.
Yeah, that shouldn't be a problem.
All right, number 4, Kelsey.
So number 4, which is 2018-062-551, this one will give a little bit of context to that conversation we were having earlier about the fraudulent entities. So this is one of the timeshare-related fraud cases that involves the impersonation of a licensee. The licensee reached out to the commission with evidence that this fraudulent and to date unknown entity is using their license number and firm name in furtherance of its scheme. The licensee has reached out to private attorneys, the Attorney General's office, the commission, and local law enforcement to try and identify who is using their information. Representatives of the legal division have tried to reach out to the Attorney General's office for additional information but have not yet received any updates. Council recommends the commission authorize a formal referral to the licensee's local district attorney and or the Attorney General's office to request that action be taken to identify at the least the owner of the website which makes use of the licensee's name and license number. And again, that recommendation is for a formal referral. And actually, if the commission would be willing to entertain it, I'd like my motion to be for a formal referral for any licensee that is currently being affected by this. This licensee in particular has been very proactive about reaching out to us, and that's why I used them in the report. And I'm not saying other entities aren't doing anything. We're just not really getting updates as quickly as we would like to be. So again, recommendation is for a formal referral.
Can you not go to, and I forget what it's called, to see who the owner of a that's only a domain, not a website.
We have been able to track down the domain hosts, but without a subpoena, those hosts are not going to reveal the individuals.
They can pay a certain amount of money to remain anonymous.
I think, my question is more procedural. I mean, you send it off for a referral, and is this something that's going to trigger the other entities to automatically notify us, or is this going to be where you're going to require to phone them once a month, a quarter, and see what's going on with the...
So a formal referral would really just, it wouldn't be something that we'd monitor. It's kind of just like putting it in writing that this is something the commission is taking very seriously and wants other enforcement agencies to pursue. Now, we could have it on an ongoing basis, but usually it's just
Specific.
symbolic, yeah.
So the problem, Jeff, with the referral, which is the right recommendation to make, is when it gets to the local district attorney, he or she has to prioritize this referral along with murders, rapes, kidnapping, sex trafficking, meth production, cocaine, and a lot of other items, and somebody actually trying to sell real estate without a license or hoodoo somebody on the internet is not necessarily a top priority. We can't make the district attorney locally put this at the top of his list.
We can't. But we can let them know that it is something the commission is concerned
Oh,
about.
it's in their file at least.
I mean, essentially what we need is somebody with subpoena power to figure this out, and we just don't have it.
All right, you've heard the recommendation. Is there a motion to accept that recommendation?
I'll make a motion to accept council's recommendation.
Second. I have a motion by Ms. Franks, second by Mr. Wood. The council's recommendation be accepted and this complaint be referred to the appropriate county's district attorney. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 5.
Number 5 is 2018-042131.
We've heard this before, but you have new information, correct?
Yes.
Let's go to the new information.
This is our, let's see here. Okay, this relates back to the options. New information, an individual's unexercised option to purchase does not qualify that individual as a property owner, subject to the owner exemption under Tennessee Code Annotated 6213-104A1A. The definition of broker under TCA 6213-102 includes individuals who solicit or transact in options. Council is of the opinion that it would seem illogical to permit an unlicensed individual to transact in properties they do not currently own when merely marketing the option itself would constitute a violation. My recommendation is for a $1,000 civil penalty for unlicensed activity.
Move to accept council's recommendation.
Motion by Ms. Franks, seconded by Ms. Taylor. Council's recommendation be adopted, and this fellow be offered, or lady be offered, a $1,000 civil penalty for practicing real estate without a license.
Were there 3 properties, though, they were advertising this way? I thought I read that it was 3 examples.
At that time, I had found 3, I think they were like Craigslist posts. Now, I will say, and this is kind of my mistake, I'm not sure if I could still find those 3.
Well, I'm not worried about the number of posts. I'm talking about how many properties were in the post.
Each one was a separate property.
It was just one house, one property.
Right, at that
Okay.
time. And I'll admit, like, when I was looking up new information for this, my analysis really pertained more to the law and not what this individual was doing.
Okay.
So I couldn't say for sure how many, but at that
Okay.
time, there were 3.
Okay.
Ms. Hills.
The respondent did not deny paying referral fees.
Right.
Did he say who he pays them to? Does he pay them to
No,
licensees?
it was my understanding that they would just get on social media and say, hey, if you see any properties that are looking kind of run down, send them my way.
Flippers.
All right, thank you.
All right, so before we vote on this, your recommendation reflects a discussion item we're going to talk about at the end of the meeting today.
Yes.
It's consistent with what that recommendation is going to be.
Yes.
And if I can paraphrase it, just so I'm clear, if a person ties up a piece of property with the intent of trying to find somebody else to buy it before he has to close on it, you're saying he has to have a real estate license.
Yes.
That's legal's.
Yes.
That's your interpretation.
Yes.
All right.
I think the real thing you're saying, they don't own it.
That too.
They're not the owner.
Yeah.
So they're not exempt.
That's right.
So I will discuss that further, I guess, when we get to the agenda item. But in case the commissioner doesn't agree with that interpretation, say the chair, for instance, he would vote against this motion, right?
Correct.
I just want to make
That
sure.
is what he would do.
Or she, if she
Or
were.
she.
So let me just be,
Do we not need to have that conversation before we go to vote on this then?
As again,
It was
you
on the-
speaking, it triggers other things
Yeah.
in my mind. This is the second or third time today. Thank you very much.
I should speak more.
Yes, you should.
I don't think so.
So, I thought I had my arms around this with this, thinking about it through one set of glasses, but there's another set of glasses.
So would you prefer to put this off until we
Please.
have the general discussion on the topic?
Yes, please.
All right. Without
'Cause
objection,
I'm not
we'll come back and
comfortable
get
now.
this one.
Number 5.
Yeah,
Okay.
I'm not comfortable now.
The motion at the moment, if we get back to it, is to accept council's recommendation.
But I was also going to add what the prior recommendation was to cease and desist, added
So
to that.
would you prefer to just take a motion off the table? We'll start over on this after we've had the discussion?
Yes.
Without
Yes.
objection, we'll do that. All right. Next, please. Number 6, right?
Yes. Number 6 is number 2018-015591. This one is for the hearing that was previously scheduled for tomorrow that has since been continued to April. Got some printouts for you all. This is a formal settlement offer that the respondent's legal counsel has presented for the commission's review.
The prior recommendation was revocation.
Kelsey, before you give us anything, is there a chance that we could jeopardize a formal hearing by knowing too much at this point?
I don't think so, because it's public information at this point.
How did it get public?
It's always public. If you
It's
want
not to
it,
us.
I mean, the offer of settlement's not public at this point, is it?
well, no, but you all are allowed to know what the settlement offer is.
But their counsel,
Your counsel, you tell, if it's okay to see this and discuss it, I'm okay with it.
It's okay.
Okay.
the respondent's counsel has submitted this formal offer.
And I think this is one I'm familiar with by reading this. Is that right?
No.
Thank you.
Thank you. All right, so, yes, this was for a respondent who is a principal broker. Legal was able to identify 30 different instances of commingling or an improper disbursement. Typically, by improper disbursement, I mean the escrow payment was coming out of the general funds account, not out of the escrow account. In the notice of hearing and charges that was filed, the council requested revocation, or in the alternative, a downgrade of their principal broker's license. And just to be clear, when we say or in the alternative, that doesn't necessarily mean to the judge, we'll take either or. It's really just preserving some sort of discipline should the judge feel like revocation was too far. So really, we were just looking for revocation. This is a settlement offer from the respondent's counsel. I'm legally required to share it with you. It's your decision. If you would like to know my recommendation, I'd be happy to share it, but I wanted to give you all the opportunity to review it and discuss it before I chime in.
I think that what they've offered is a long ways off from revocation, that it would just be for 1 year, that they would be able to commingle 30 more funds in 1 year. I feel like we're way apart on this one, or at least I am in my mind.
I think we really talked about this.
Well, let's try this, commissioners. Once we're through discussing, our chair will entertain a motion to accept the proposal from Mr. Collins on behalf of his client, and if that motion does not pass, we'll continue on the path we're already on. Further discussion?
Is council going to give their opinion? Or
No,
tell
let's
us?
not take it.
Let's
Let's not take it.
Why would we not take our council's opinion?
Let's just see what we think about this, okay? We might be able to keep this thing moving. Is there a motion to direct council to accept the proposal from the attorney for Mr. Jonathan Shane Forster?
I make a motion that we do not accept this.
I don't want I want a positive motion. Will you make a motion to do this or not? All right, last call. Any motion? All right, at this point, the chair is going to rule that no motion came forward, and so this proposal is of no effect and will continue on with revocation. Okay? Thank you. Next, Erica.
Yes. See, number 7.
Now, do we have to vote to revoke? Or
We already did.
done it?
We already
Okay,
did.
okay.
This is a settlement offer.
Okay, all right.
Number 7 is 2018-066-131. And I'm going to start with just the first paragraph and see if you'd like me to paraphrase going on from that. Complainant is a licensed agent and respondent is a licensed principal broker. Complainant alleges respondent is practicing real estate with an expired license. Respondent allegedly received and presented an offer from complainant on September 1st, 2018 without an active license. Additionally, complainant claims respondent is the principal broker for their own firm. Complainant claims respondent's license expired in March 2018 and alleges respondent closed 3 real estate transactions in the meantime and has 1 pending. Additionally, alleges respondent is acting as a property manager. Complainant alleges respondent told them that they could not present respondent with offers that have a 24-hour response deadline, but complainant believes there's no legal minimum response time requirement for offers, and it should be up to the client on such deadlines. So basically, the complainant makes 2 allegations that the respondent was engaged in unlicensed activity because they had an expired license, and that they are telling the complainant as an agent not to send them offers with a 24-hour response deadline. So if you would like me to read the rest of it, I will. Or if you want me to,
What's wrong with telling someone that not to send it for 24 hours?
I didn't think there was anything wrong with that. I felt the only violation was unlicensed activity.
Okay.
So, is it okay if I make the recommendation, or?
I want to hear it all. Okay.
Okay.
Pretty straightforward.
So my recommendation is to offer a consent order assessing a $2,000 civil penalty for unlicensed activity in violation of TCA 62-13-301, $500 per month of unlicensed activity.
Move to accept council's recommendation.
Second.
Motion by Mr. Diaz, seconded by Ms. Hills. The council's recommendation be accepted and the respondent be offered a $2,000 civil penalty.
Is this the one also that he was basing that upon the fact college football teams play?
I really wanted to mention that. Yes.
Yeah.
Yes. So allegedly the respondent said you need to consider that everyone's going to be watching Tennessee college football this weekend and we're not taking any offers.
Okay, I would also like to do this then. If you would accept this, maybe that the agent needs to have a 4-hour contracts class also, because they need to do what their client wants, not what works out for their personal schedule.
And this is a principal broker.
Yeah.
So, no, that was the number 7.
Well, Commissioner Wood, I would just say that it does say in the fact set that the broker did not say because of football. It's a fact that people aren't entertaining offers. He didn't say you couldn't do it.
Right. And there's these, honestly, from the file, from everything that I read in the file, the complainant is just making these allegations. The respondent did follow the instructions of their client.
Okay, I'm
and,
good.
and presented all offers, and
Okay.
I really didn't think there was a violation there.
I
But
think,
it was a
I think
kind
my
of funny.
vision's just clouded as a Vanderbilt graduate. My vision's just clouded. Is what it was.
Just think of it.
I was wondering if it would be brought up. It's funny.
I would agree that your vision is clouded.
It is clouded.
All right, the motion, if accepted, Ms. Taylor.
Well, I think, aren't there four issues instead of, I would rather do $1,000 for per contract.
For
recommendation basis on the fact they were unlicensed for 4 months, so she's proposing $500 per month. You may want to do it on a contractual basis as opposed to a monthly basis. Fine with me.
I didn't have any proof. That was just allegations of transactions, but I do have proof of months. But we can raise it if you feel like it's not enough.
Can we raise it, well, no, it's $500 a month for unlicensed, period. That's
what I was recommending.
All right, the motion's on the floor. Any other discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 8.
2018-070-641. Complainant is an anonymous concerned citizen and respondent is a licensed firm listing the property involved in the transaction at issue. The complainant does not really explain how they are involved or if they are directly involved in this transaction, but makes the following complaints. Complainant alleges there was a property under contract and it was discovered that 4 out of the 2 units were, quote, not legal and in bad condition, but still being rented, unquote. An unnamed agent allegedly informed a listing agent and the broker that zoning did not permit the 2 units in the basement to be used. Therefore, complainant claims the offer on the property had to be withdrawn at that point, but alleges the listing agent and broker are allegedly still listing and advertising the property as having 4 units. Despite knowing this is not true, complainant also alleges the agent and the broker relisted it as being grandfathered in, but allegedly admitted this is not true because they did not provide documentation to complainant. The complainant is basically worried somebody could buy this property under false pretenses. And the main allegation, and the one that I'm most concerned with here, is that the complainant alleges the respondent's firm license was expired the day that they filed this complaint when they checked on Verify. So counsel looked through the licensing record and a note was entered in the account on October 16th, 2018, stating the respondent had been expired since July 17th, 2018. The license was renewed on November 5th, 2018, so the respondent was engaged in unlicensed activity for almost 4 months while expired. I felt that the zoning issue, because the firm did not verify that the zoning was correct before listing it, that's being negligent. That's not engaging in reasonable skill and care. And then I also felt of course, the issue with unlicensed activity while the firm's license was expired was an issue. So if the commission is okay, I'd like to go forth with my recommendation, unless you'd like more details. Okay. So the recommendation was to offer a consent order assessing a $2,000 civil penalty for violations of TCA 62-13-301 for unlicensed activity and TCA 62-13-4031 for reasonable skill and care.
So if I was representing this person as their attorney, I would be wondering, how can you get them for unlicensed and at the same time skill and care?
And I just am now. That's a very good question.
She looks closer to this.
I feel like I believe that you can because they're licensed in the first place. They have to follow the act, and because their license is expired doesn't mean they're not licensed anymore. So they still therefore have to follow the act as an agent. Now, if it was a completely unlicensed person, I think that argument may have some weight.
Attorney, would you like to object
I would
to
say
that?
it would have to be one or the other.
Well, then why don't you take control
Maybe
of the floor
I should
and make
go
a
to law
motion?
school.
Would you like to propose something different than what council's recommended?
We can stick with $2,000, same as 500
I'd like to make a
times 4.
motion that we have a consent order assessing a $2,000 civil penalty for violation of TCA 62-13-301 unlicensed activity.
Second.
Okay. Is that like, again, $500 a month kind of concept?
It would be exactly, 500 times 4.
All right, the motion offered by Ms. Franks and seconded by Ms. Hills, if passed, would offer the real estate firm a $2,000 consent order agreement. Mr. Diaz.
I was wondering, were you able to confirm that they continued to advertise the property as a 4-bedroom or a 2-bedroom
No.
after notification?
No.
Okay.
Other discussion? Let's vote on the motion. Those in favor vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 9.
2018-072-841. Complainant remains an anonymous licensee, and respondent is an actively licensed agent. Complainant alleges respondent has been expired for almost a year per Verify at the time this complaint was filed on October 16th, 2018, and alleges they're still practicing and advertising real estate with an alleged 16 active listings on the MLS. Complainant provides no further detail, doesn't provide any documentation or any information to support the allegations. The respondent did confirm in their response that they did not realize their license was expired until they received this complaint. Respondent mistakenly assumed when they paid their local dues, which included a state line item, that it was also the renewal fee. And I looked at that, what they're talking about. It says, state dues, local dues. The respondent immediately took action the day the complaint was filed. They provided proof that they did in fact pay the full amount that was due to our office, and they met all the requirements the day this complaint was filed, and they became active that same day. They provided documentation demonstrating their due diligence for continuing education, for 2018 MLS dues, and then, of course, the dues they owed us in the amount of $880. They apologize for their oversight and mistake and states they are now clear of what is expected of them and required by the licensing board and will not let this happen again. Our records show respondent's license expired on December 25th, 2017 and was not active until almost 10 months later, as explained above. This respondent has been an affiliate since 2005 and should be well aware of licensing requirements. Therefore, council recommends assessing a $1,000 civil penalty for unlicensed activity. And I know that this doesn't seem consistent with the last two because this is a 10-month unlicensed time frame, but I have no proof of anything specific that this person was doing in those 10 months as I do in the prior two complaints, but I do have proof that they were unlicensed for the 10 months. So if there needs to be a discussion on the amount of the civil penalty, I'm definitely open to discussing that.
Motion to accept council's recommendation.
Second.
Motion by Ms. Hill, seconded by Ms. Franks, that council's recommendation be adopted and this licensee be offered a $2,000 civil penalty. $1,000 civil penalty.
Which I think is lenient because they've renewed 5 successful times.
I know,
before.
I did too.
But we have nothing else to base it on. So.
All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion
No.
passes on a 5-aye, 1 no vote. Mr. Wood votes no.
I just thought it was light. I mean, they are almost a whole year without license, and that just seems light.
So if she doesn't have any other stuff, what they did.
All right, let's get on to number 10.
2018-073-421. This complaint was opened administratively when respondent, an actively licensed principal broker since 2005, notified the commission of pleading guilty to preparing a false tax return. Respondent is currently serving out their sentence and will not be able to respond per the licensing division who opened this complaint. The respondent sent a letter to the commission dated August 3rd, 2018, stating they were sentenced that same day for a felony regarding a tax preparation business that they previously owned. So separate from a firm, they had this tax preparation business while they were licensed. Respondent provided a copy of the judgment and explained they will have to leave the state to serve a 90-day sentence. They will not have access to email or mail during that time, but hopes to reestablish communication with the commission once this sentence is served. Respondent understands there are rules that pertain to maintaining a license after a criminal conviction, and they will follow any requirements deemed necessary by the commission. Respondents provides their phone number, which they had access to until they left the state to serve the sentence. They have already been released. They were released December 7th. The judgment was filed in federal court, in Tennessee stating they would be on supervised release for 1 year after serving their sentence, and also requiring respondent to make restitution in the amount of $379,000 and $540 to the IRS in one lump sum payment. Council recommends assessing discipline by either offering respondent a consent order to downgrade their license from principal broker to an affiliate status after a lengthy suspension, or offering a revocation if the commission feels that's necessary. Additionally, the commission could first require a respondent to make an informal appearance before you to discuss this matter and ask them whatever questions you would like before making a decision on the discipline.
All right, commissioners, thoughts?
Well, so since he's convicted of a felony, does his license automatically get revoked? Am I not understanding that correctly?
I'll have to look at it exactly, but I think it says when they're supposed to notify the commission within a certain time frame, which is why we got this letter.
Okay, and then that's a decision the commission has to make whether or not to revoke. It's not automatic.
Yeah, I know that's what we did with the.
Yeah, we can pull it up exactly, but from memory, I think it says that they have, I want to say something like 60 days to notify
I think it's
us.
automatic if you don't tell us. It's
Yes.
automatic revoked, but they tell us, and then we got to make a decision on it.
We recently had
Yeah.
something similar, and we offered a revocation, which they happened to take because they told us.
This person is incarcerated.
They're out now.
Out now. Out now.
On supervised release, but still
Who's
actively
the
licensed.
principal broker? This person's still
They,
a principal broker?
Well, I'm sure they've had a principal broker.
No, no. Are you sure they have?
Well,
I mean, are they back to the principal broker now? That's my question.
No. They still have an active license.
Sure.
I
mean, don't we have to tell the state who the principal is?
Released December 7th of 18.
Another question, have they paid the IRS that money?
That I don't know.
What, you don't know if they're the principal?
No, doesn't know if they've paid the IRS.
Oh.
Had to be paid in one lump sum, and that would
Usually
be a part
after
of their...
everything has been met, then we discuss it. Like, if they've not paid that sum,
Then well, there's no
they
reason
can
to
do,
entertain
yeah.
it.
I mean, I choked on
It's a
that
big
number.
statement.
I'm sure there's a time frame that they have to pay that within, especially one
It says
lump sum.
one lump sum, yeah.
Oh, so let's just, for the heck of it, if anybody wants to just put a motion out there, you don't even have to believe in it at this point. Let's just see what kind of reaction we get to. So we have something to talk about.
I
Ms.
make
Taylor.
the motion to revoke the license.
All right,
Second.
there's a motion by Ms. Taylor, seconded by Ms. Franks, that this license be revoked. Discussion on the motion. Ms. Maxwell.
This person is at a firm by themselves.
What?
There's no other agents at this firm.
So they're
They are the
principal broker
principal.
today?
What?
Are they principal broker today of that company?
Yes, but they have no supervising affiliates.
They still got an earnest money account, they got all kinds of things
Yes,
going.
yeah.
Revoked, and that would...
It only
take the
affects that
firm,
one
too.
person that did
Yeah,
the crime.
Yeah, that's not a small,
Yeah, that's a crime.
that's not a small little thing
prison.
to do there.
Go ahead.
I was wondering, so the time the person was in prison, they just kept their office open with him being the principal broker? He didn't shut it down or anything, did he? Or they didn't?
The letter we received was just basically what was outlined here, stating what you have and letting the commission know.
And they
I'm
pled
just not
guilty.
clear on a timeline. Did he notify us when he was convicted, or did he notify us after he got out?
Convicted.
Okay.
So,
Other discussion on the motion.
I wonder, do we want to entertain the possibility of them coming back as principal broker, or you want them out?
To revoke, they'd
Okay.
have to start back over with an
Serious.
affiliate license.
I just want to understand.
So we could offer a consent order for voluntary revocation.
so we're revoking the licensee based on their criminal conviction?
That's what's in front of us.
Okay.
This is a federal conviction. Does that qualify for fresh start consideration too?
Yes, it does.
So if we revoke the license and he comes back and says, I want you to reconsider, we have to.
No, so we can revoke the license based on the Fresh Start Act. We just have to go through the factors and the justification statement. They would then, if they disagree, have the ability to appeal to Chancery Court.
Wouldn't he be a felon right now? And I mean, this is such a, I mean, it's just done. And I think that with the severity of the offense, we need to revoke his license.
That's what's in front of us.
But we'll need to go through this, right?
Yes.
Well, only
back.
Only if he appeals, right?
No, because
But
we are
today.
taking a disciplinary action based on a prior criminal conviction, which is this, even if it's one of our convictions that we look at, we have to make a fresh start analysis. It covers licensees and prospective licensees.
About what he's done after then, so I think I'm still good with my.
Yeah, we're good with it. We just got to go through this.
As a point of clarification, when do we have to go through the fresh start questionnaire? If we vote to...
If you vote to deny, to revoke the license, we'll then go through the fresh start analysis.
Like in just a minute, maybe.
Yes.
All right, other discussion on the motion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Ms. Matlock.
Could you tell me who seconded? I know it was Commissioner Taylor made the motion. Who seconded the motion?
I did.
Okay.
All right.
Okay. So, hold on one second. You have the Fresh Start Act in front of you. That was printed out for you today, which is pretty timely.
So is this something that has to be read out loud, or is this something we can look over and say we agree to all of this?
So we'll need to have a discussion on the different factors.
Okay.
We'd have to say
All right, so get
A,
us
B,
going.
or just one, or what? What do we have?
So I'll read the different factor, and then you guys can have a discussion on that factor and how this conviction applies to the factor. So the first factor is the nature and seriousness of the crime for which the individual was convicted.
It's just about as serious as you can get.
Is that for AI? Is that where you are?
Yes.
Thank you.
So how would you like a response?
So when we're doing this, we want to make sure that we have an analysis that we've considered the criminal conviction, and we want to, how this directly relates to the real estate industry. So keep those in mind when you're having your discussion of the factors and why you think that this criminal conviction should apply to the revocation based on it directly relating. So the nature and seriousness of the crime for which the individual is convicted.
Oh, if we think it's serious enough that we can, would you say we agree, or you want a motion that says?
Just where, so the factors are there for discussion purposes, so you don't have to, it wouldn't just be simply yes. So someone would make a statement or have a general conversation about it. But before that, do we agree that this conviction directly applies to the real estate industry?
Yes.
Okay. And now we'll want to consider the nature and seriousness of the crime for which the individual was convicted.
Great deal of money from one of his other companies, and because he is the agent and broker of his real estate company, he has access to earnest monies and other monies in the hands of the buyer, seller in his company, and I don't think that it appears he's very untrustworthy.
With no oversight from anyone
Yes.
other than himself.
Exactly.
Okay. The length of time since the commission of the crime. The length of time since the commission of the crime.
The crime was committed when?
It's 9/7/18, isn't it? No, that's when he was done.
We
That's
don't, I didn't see where we have the information of when it was committed. I just know they were sentenced on August 3rd,
Right.
2018. I imagine it was quite some time ago.
Right.
If it's a federal case.
It says a 90-day sentence, so if he was sentenced on August 3rd, then
So, it's so
He could have been charged 2 years
I would
before
think
that,
the
though.
commission of the crime could have been quite a while ago.
But it's still pretty recent, though, period.
Yes.
It wasn't 30 years ago, so it's pretty
Right,
recent.
or 10 years ago. So it is very recent.
Okay. The relationship between the nature of the crime and the purposes of regulating the occupation, profession, business, or trade for which the license, certificate, or registration is sought. So here we would be looking at the relationship between the nature of the crime and the real estate industry.
Well, it's basically a theft of money.
Deal with
we
our
deal with
clients' money on a
daily.
daily basis. So.
under his direct care.
Yeah.
Under his direct.
So what I'm unclear about is it just theft of money, or did he just not pay his taxes on the money he earned?
Wouldn't that be theft from the United States IRS?
It may be. I'm just trying to make sure. To me, there's a difference if I don't pay my taxes or if I go steal $370,000 from somebody.
Restitution.
Regardless, it's a monetary crime.
Restitution means you've usually taken it from somebody. Doesn't
Or else you
mean-
wouldn't be paying
yeah,
it
right.
back.
Mhm. It wouldn't be back taxes.
It's-
It would be something else.
It seems like they were preparing taxes from many people, all of their clients. So it could have been theft or fraud for multiple clients and multiple tax preparation.
So it wasn't just for themselves.
Right. No, they were preparing taxes. It was a business that they owned.
The number 4 is, excuse me, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. So the relationship between the crime and ability and fitness to perform the real estate duties.
Well, he's proven that he can't be trusted by his clients. So,
And money.
And
Yeah.
care of other people's monies.
so that's going to inhibit his ability to be able to do real estate.
Any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the occupation, profession, business, or trade.
Got no knowledge of that right now.
None
Yeah.
that we know of.
That's correct. And 6 is any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade.
Well, we go by state law, so what federal law would you be asking for?
So for this one, there aren't any federal laws that would apply here. Okay. So I will first need a vote before I read. We're going to need 2 different votes. So we've already voted, but I need a motion and a roll call vote that this conviction of preparing a false tax return directly relates to the real estate industry.
Second.
I have a motion by Ms. Taylor, or seconded by Ms. Franks, that expresses that motion.
Ready for a
Roll
roll
call
call?
vote.
Commissioner Jeff Diaz,
I'll vote aye.
Commissioner Marcia Franks,
Yes.
Commissioner Diane Hills,
Yes.
Commissioner Fontaine Taylor, Commissioner Bobby Wood,
Yes.
Chairman John Grease.
Yes. All right, Ms. Matlock.
Okay, so I'm going to read the justification statement into the record. The Tennessee Real Estate Commission on February 13th, 2019 decided to revoke the license as a result of your conviction on or about, sorry, hold on one second. August 3rd, 2018, for filing a false tax return. The Tennessee Real Estate Commission has decided to take this action after considering the following factors as set forth by the Fresh Start Act. If you wish to contest this determination, you may file a petition within 30 business days of the receipt of this notice in Davidson County Chancery Court, at which time the Commission must demonstrate by a preponderance of the evidence that the licensee conviction is related to the real estate industry. That's it. So we'll need a
Make that motion.
motion to accept the justification statement.
I'll make that motion.
Second.
Mr. Wood makes a motion to accept the justification statement, and Ms. Hill seconds that motion. Discussion on the motion. Let's vote. Let's roll call it again, Caitlin.
Commissioner Jeff Diaz,
Aye.
Commissioner Marcia Franks,
Yes.
Commissioner Diane Hills,
Yes.
Commissioner Fontaine Taylor, Commissioner Bobby Wood,
Yes.
Chairman John Grease.
Yes. All right, that motion passes on a 6-0 vote. Have we completed our task related to the Fresh Start Act?
Yes, thank you.
Ms. Matlock. Where's Shalina?
Huh?
Are you going to be Shalina?
Who's Shalina?
Well, I guess it sort of remains to be seen. I think there was a little bit of a miscommunication, and I think that Shalina stepped out. So I guess it will fall to me to do the represent. I know that I need to get a copy of that because I wasn't planning to do that. But yeah, I guess if I can just read it.
I was kind of hoping we'd get up to a total of 5 attorneys in here at one time.
How many are on staff? We need to strive for more.
Well, I fall into a special category. You all are not. I'm here gratis
You are.
for
You're
the commission. You all, this one is on the department. Let's just say. So
I
it's
got
not-
it.
Okay.
So let me ask you, are you familiar with these 2 cases?
A little bit. I have not really dug into them, but my understanding was that there were some. I know sometimes you all would rather that we kind of sum up rather than read everything. These were some cases that were a little older, and there were some violations that were found. But I think that Shalina's represent basically lands on she didn't think that there was anything that rose to a level worth.
Let's go to new information on the
Okay.
first one.
And so I guess just to read that into the record. I think-
Even before you do that, Art, we've had this before to take a look at. Is there a desire for this to be read into the record at this point? We know that you'll get the case number into the
Yeah,
record.
just the case number. Just read the
Okay.
case number into the record.
All right, let's do that and then hold up on the new information and see if we have any questions.
Okay. So this one is number 12.
11.
Number 11. I think I was pardon me, I think I got a little bit out of order. Okay. So number 11, that is case number 2017-017-571.
And in the new information, the very last sentence is a telling sentence.
We cannot go forward.
So the last sentence says, we cannot go forward with a violation for failure to supervise against the respondent broker because it is not possible for an individual to supervise him or herself.
Does anyone want to argue with that logic?
We could.
If not, is there a motion to accept council's recommendation that this case be closed?
So moved.
Second.
I have a motion by Ms. Franks, seconded by Ms. Hills, that council's recommendation be adopted and this complaint be closed. Discussion?
No discussion.
Let's
Well,
vote.
I'll say this: is 11 and 12 are they the same case or different cases?
One is against, it arises from the same occurrence. One is for the purported principal broker. One was for the affiliate broker.
We can, if that's your desire, if you'll read the second case into the record too, the number.
Absolutely. Number 12, it is complaint number 2017-017-611.
Mr. Diaz has modified the motion to include both cases in one motion both recommendations are to close the case, the complaint. Is there any objection to that modification to the motion that's on the floor? Since there is not, I need a second for the record from Mr. Diaz from Ms. Franks. Now, is there discussion, or are you ready to vote?
Ready to vote.
Thank you, Ms. Franks. The motion on the floor is to accept council's recommendation on both cases. Those in favor of that motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. You did an excellent job of representing Shalina. Thank you. Okay, we're going to, for the record, we're going to take a quick 5-minute break. We've got to come back and finish number 4. We've got a couple discussion topics, and we'll be done.
Man.
Yep.
Was this his son?
Yes.
Talking about Grover?
Daughter.
He's her.
Oh, yeah, Grover.
All right, Jeff, are you going over like recipes with Caitlin or something on there? That's what it looked like to me.
I had to get the cookie recipe that she used.
So we expect next month to have your version of our cookies.
No, I'm going to keep them.
Yeah,
keep
there
them.
you go.
Well, since we're in Memphis, you can have some, but the rest
We're
of them.
not in Memphis next month.
All right, so when we last left, we're about to go back to Miss Bridges. And before we made a decision on what Miss Bridges presented to us, we were going to let legal explain to us their interpretation of what's captioned on our agenda as options to buy. And who's, from the array of staff attorneys here today, who's going to make that presentation on behalf of legal?
That would also be me.
Ms. Bridges, you have the floor.
So my analysis is pretty much in line with my recommendation from that case earlier. My research has indicated that an option to purchase does not constitute ownership, therefore qualifying one for the owner exemption. I think the simplest explanation, again, which I put in the report, is that if the definition of broker includes one who transacts or solicits in options, it would seem unlikely and illogical that the legislature wanted to permit somebody who's bought an option the ability to market the house if marketing the option itself is impermissible under the Act. Now, I've also done research into what does an option actually provide you with. Some people like to argue that it gives you equitable title and therefore you have an ownership interest. I completely disagree with that reasoning. My case research indicates that an option to purchase is really no more than an extended offer to sell, and it's binding on the optionor, not on the person who buys the option. Even further, I mean, even if we were to say that you get an equitable title, therefore giving you ownership, which you don't, but even if we did entertain that argument, the equitable title would only exist upon exercising the option, which means you have committed to buy the house yourself, which means you're the owner. So then it just, there's no point to even go down that line. So my conclusion is that an unexercised option to purchase does not give you ownership of that property. Therefore, you do need a license if you're going to transact in the property itself or in the option.
Okay, Commissioner Reeves, what do you think?
So
Ms. Hills.
So if I had a purchase and sale, and I'm the buyer, I can still sell the property. I can try to sell my contract, sell the property.
I think you could probably. I mean, no. If all you have is a purchase and sale, you haven't executed anything. I don't think you could, or you haven't closed on anything. If you don't own the property, then no, I don't think you can market that property for sale.
This means they can't sell it to anyone other than you. They have to sell it to you first.
But I could assign it, right?
Yeah, you can.
Yeah.
Mm-hmm.
Which is really the same thing. Mm-hmm. That's the same thing.
That's why you always put in or assigns.
Uh-huh. So, but I would think the option, and I don't deal in options. We have had occasion that someone has assigned their purchase and sale. And, but you would think that the option could say about anything at once, sort of like a purchase and sale could say about anything at once.
So I'm going to put this out there. So I deal in commercial real estate. You're talking houses. So I've worked with developers before who've tied up property with a form, the acronym is CREPA, Conditional Real Estate Purchase Agreement. That's what it's for. And inside that purchase agreement, the developer or assigns, because it will almost always be assigned once an LLC is set up for that particular property, ties the property up for as long as that person can tie it up for. And even tries to build some extensions or options on the end of it to make it tied up even longer. It might cost some money at some point. But the whole purpose of doing that, in this particular case, is to go out and try to find potential tenants for a center that would agree to go there if the center is built. Okay? Now, your interpretation would say that developer wouldn't have the right to go out and do it. I know you're talking about homes and buying. I'm talking about commercial and leasing. But those are all covered in the Brokers Act as well. And it's just hard. I can't picture that situation not being a legal operation of law activity.
If the developer doesn't own the property, I think they need to be acting through a licensed broker.
I'm going to suggest to you
Because
that
you are that licensed.
no,
If you're negotiating getting tenants, aren't
I'm
you?
not necessarily. The developer may be doing it. He may hire me to go find tenants, or he may not. I mean, there are developers in Memphis, Nashville, Upper East Tennessee, and Knoxville who develop retail space all the time. They do it themselves because they've got the connections. It's not like they go to ICSC and they go to other places where you can find tenants and tenants reps, and they solicit tenants for a center. And if they can't get any, they don't perform the option. They let it go back.
John, I see it different. You don't own that piece of property at all, and you're only going to buy it. I mean, you're tying it up for a length of time,
Correct.
and in most cases, it's with some dollars. It's not free. But I think in a home situation, the thing that I think makes it different, you don't own it until you close. Now, you can close and then close right after that, but you don't own it till you close. And I don't think, I'm confusing myself right now, but you don't, to me, I think you don't own land when you have the option. In commercial or residential, you have to close at some point in time. You're only selling a what if. A what if you close on this where you paid that money to have the option, then you're going to rent it to people, and that's it.
My example is, I think, so somebody ties up a piece of residential property with the expectation they can find somebody to buy it for more money, let's just say. I mean, that's generally what my commercial guys are doing too. My developers are tying up a piece of property to try to add value to a property. And they're going to sell it because, or at least assign it to a different LLC along the way somewhere. I appreciate legal just giving us their position, because I can agree or disagree with it, but at least we can, as a commission, hang our hat on a position given us to by legal. I just disagree with it because I think people should have the right to tie up a piece of property to try to figure out what to do with it. And I don't think they have to hire somebody to help them try to figure out what to do with it.
But the law is the same whether it be residential or commercial.
Correct.
And y'all know when I first came on here and I heard that LLCs could not be buying and selling property, and I knew my husband was doing it that very day. And I said who, and they brought me down a legal opinion from the Attorney General's office. Now, my husband had 3 different attorneys look at that, and they all 3 had different opinions than what the Attorney General did. But I can tell you this, that our attorneys at TRAC told us that we need to rule by that Attorney General's opinion. So I'm wondering if this is as big as it seems to be, I hate putting Kelsey, what Kelsey said. Do we need to get an attorney general's opinion or?
For the record, I'll stand by what I said, even
I
if
know,
the Attorney
I know
General
you
disagrees with
will.
me.
I think it's in the statute option to buy, sell, or lease. So we could do that, but I think they're going to point to 102 4A at the very top and point out that option to buy, sell, rent, or exchange any real estate or of the improvement of the real estate or any timeshare interval as defined in the Tennessee Timeshare Act, compiled in whatever, collects rents or attempts to collect rents, auctions or offers to auction, or who advertises or holds out as engaged in any of the foregoing. That's in the definition of broker, which is regulated by the Tennessee Real Estate Broker License Act of 1973. This is at the very top of page 6.
And to me, this is, here we are as real estate commissioners. There's a lot of things, I think, that it's easy to be confused about, even us, when we're hearing it every month and judging other people by it, our interpretations of it. I'm just a pretty black and white person, and I know we can all have different opinions on any one subject, and we most times do. But it would just help us, I think, as a regulatory board. I'm glad you gave us what your opinion is.
But this says for a fee. So sometimes you
don't-
have the
you
thing
don't
that
get any
there's no
money.
fee.
No, it's not.
You're just making,
A flipper might do it.
yeah.
Or if you want to extend,
Well,
you may
It
have
says
to.
fee, commission, finder's fee, or any valuable consideration.
Yeah, but
if
you
you-
may be
that could
getting
be a
your
vote.
money on parcel one, and that's going to be fine because you're going to get it on parcel one, and you're not getting anything on 2, 3, or 4, and that's fine because parcel one takes care of your job.
It also says, go ahead.
I wonder if the option to buy is really what the person is selling. They're not really selling the property. Is that?
Well, see, if that's the case, then I think this is a open and shut matter. If they're selling the option, well, that's brokering according to the definition. If they're selling if they're marketing the property itself for sale, I would still argue that that's improper because they don't have an ownership interest in that property. Some people will argue I've got equitable title. My research says that's not true.
Okay, so if somebody, private citizen, and not a licensed person, enters into the agreement and gets an option to purchase, and then they can't. You're saying your interpretation is they can't turn around and sell that contract.
Correct.
Okay.
Yes.
Anna, did you say you agree with Kelsey or not?
I do.
You do. Okay. And John, this is where, I'm skewed being on the residential side most of the time. Most of the people that try to do these type of things in residential are not good people necessarily. I mean, they go out, and a lot of times they catch a seller that's desperate and they're needing to do something, and they'll write an offer, tie up their house for an extended period of time, but they have, in a lot of cases, they have no intent of ever buying that home. All they're trying to do is mark it up and then resell it, and if they can do it, great, and if not, it's no skin. It doesn't cost them nothing but some time. And I've seen some advertisements for that now that I'm getting in my emails, and sometimes I'll just say I'll look at and see who owns the property and search it, and it's not the people who are sending out the information. So it's more of a sleazy business in residential. Is there any way we could say that? I'm going to say residential, the people could be living in the home, where commercial they're not. Can we make a distinction that way, that you can do this in commercial but not residential?
Unfortunately, not under the language of the Act.
Okay.
There's not a distinction between commercial and residential. And one thing I'd just like to add to the discussion, oftentimes actually,
the actual practice in the real world is not always going to be in conjunction with what the statute says. The statute, as we know, was written a very long time ago. It's not unfeasible that we're just looking at a situation where the law has not caught up with what the actual practice is. But, you know, we're here to tell you what the law says, what our interpretation of the law is. It sounds like what you're telling us is, well, that's not what's actually happening. So perhaps what we need is an amendment, but that doesn't just happen overnight. You know, that would turn into a big thing down the road.
Yes, that would be by statute, not by rule.
And we're also now the only state that has grandfathered brokers, the only state now. And several of those are in the legislature.
Big changes.
You willing to carry that banner?
You talk about a big turnover in the real estate business.
I think we voted on that one time, and it went nowhere.
Well, we don't have the authority to control it.
Yeah.
It's statutory.
Yep.
All right, so Kelsey, thanks for the discussion. Let's get back to the case and let's see how we want to handle it. Weren't we referring to a particular case here?
Yes, the specific case is, let's see, number 5 on the legal report. And my recommendation is for a $1,000 civil penalty for unlicensed activity.
Consent. The legal report, not the consent.
There we go. You want a motion to kick this thing off?
Let's do it.
I'll make the motion to accept council's recommendation.
Second.
All right, we have a motion offered by Mr. Wood, seconded by Ms. Franks, that council's recommendation be adopted and this this individual be offered a $1,000 civil penalty for unlicensed activity as well as the cease and desist letter.
Yes.
All right, if you're in favor of that motion, you'll vote aye. Those in favor of that motion vote aye.
Aye.
Those opposed vote no. Chair, for the heck of it, is going to vote no. So it's 5 aye, 1 no vote. The motion passes. Thank you, Kelsey. Pardon me? All right, we've got a few items to take up. Ross, is it legal?
There were 2 more that you wanted us to look into, a summary suspension regarding numbers 2 and 3.
We put those off.
It finished all that. I threw them.
But you had a question.
Oh, yeah. Summary suspension, yeah. The question I posed that wasn't answered immediately was,
I don't think y'all ever officially voted because of the summary.
yeah,
What numbers was it?
2 and 3.
this is a situation where
Marcia.
I suggested that this licensee could move their license and nothing could help keep that from happening.
So there is, technically speaking, an option for a summary suspension, not under our act, but under the Uniform Administrative Procedures Act. In that case, though, it requires a clear showing of an immediate risk of harm to the general public and welfare of the public. I don't think that we could make that argument in this case because the individual at question, their license is currently suspended. So while, yes, technically they could pay the E&O, they could get their coverage, something that they could do down the road does not mean an immediate risk. Now, the other thing is if we were to proceed just under an offer of voluntary revocation, yeah, most likely they're not going to sign it, which means in 30 days we can schedule a hearing. Then most likely they won't show up and it'll be a default judgment. If we proceeded under a summary suspension route, that would give them new grounds to challenge the validity of it. I think the safer course of action to ensure that it stays final would be to go with the standard revocation procedure.
This will help my decision. How much money are we talking about? How much is alleged not to have returned?
Well, the complainant alleged $8,000. We really don't know because this person refused to provide us with information.
The complainant?
No, the respondent.
Okay.
You don't think it could be more than 8,000, do you?
Could be other
With
people.
other people.
Yeah, but we just don't know.
I believe it's probably going to be more. There are 2 other pending complaints probably coming down the line from this individual. So I'd say at least a couple thousand over.
When those
that.
complaints come before us, can you all tell us this was the one that we spoke about in February?
Well, we can reference, it would show up, I believe, in their history.
Yeah, ideally, by the time that complaint came across our desk, this matter will have already been resolved because they won't be licensed anymore.
Also, I believe that if it was in the commission's decision, we could make the decision to lump those other 2 complaints, even though they're not on the legal report today, and with these 2 complaints, so we don't have to look at this issue again. If you would decide, because the other 2 stem from this activity, from the same individual and same firm, you could make a decision today to just go ahead and revoke the license and include those complaints as well.
Based on what you just told me, why couldn't I assume this guy or girl really is a threat?
Well,
There's a pattern now. I mean, now we've heard about a pattern.
there is a pattern, but as Kelsey said before, their license is suspended. We've been unable to contact them. Their business is closed. We don't have
Business
any.
you know about is closed.
The business that we know about is closed. So I really believe that the avenue that we should do is, if we could, like we were saying before, flag this individual if they were to be licensed, try and hang their license again, but again, that will require them to get another broker to accept them and all of these other kind of things. So we can get a consent order out, sent very soon, and so that 30 days clock starts ticking, and then a hearing would occur. I do not believe, based on these facts, even though there is a pattern, that the immediate health, safety, and welfare of the public is at risk, as this individual is not operating currently.
That you know of.
That we know of, but we also, as we said, that we're operating on the presumption of innocence as well. We do not have definitive evidence that this individual has done this, as this is a complaint and they have not responded, so we can't make an adjudication as to whether this activity is confirmed or not.
Okay, so let's get back to the recommendation, which is to offer revocation as a consent agreement, a consent order. Is that correct?
Flag the licensee and offer revocation with regard to the firm and the individual.
For this and the other cases that are.
I'm going to look those up real quickly so we can read them into the record.
Okay. Selena, do you have anything you want to say?
Well, yes, I do. But just one other thing I wanted to add is that just remember, if bypassing a summary suspension today does not mean that you are bypassing summary suspension going forward. If we hear some more, we've got 2 more in the pipeline. If you vote for revocation, we'd like to lump those in. So we have one package to send them. That would be 4 complaints. But if we hear something else, we can always start that process again. And that would just involve, if we get any more information that they really are working or something like that, then we can always, the provision is there for us to do a summary suspension at some point in the future. So it doesn't foreclose that option at all.
So would that be your recommendation to us?
What would
that be your recommendation to us then?
My recommendation would be to go with council's recommendation, and then, like I said, we'll keep an eye on it. We'll flag it, and if we hear anything else, we can always have a summary suspension at that time.
Do we have a motion?
I'd like to entertain a new motion if somebody'd like to make it. I think we took the motions off the table when we came this time.
Okay, well, I make the motion to revoke the license.
All right, so your motion to accept council's recommendation. Okay,
yes.
thank you.
On number 2 and 3?
I'll second it. But also, she was going to flag it too, right?
And flag.
Flag it.
Okay.
And also flag.
And include the other 2
And include
cases.
the others.
Well, not yet.
Oh.
I don't think.
We need Ms. Matlock to read them into
I
the
don't know how we
record.
can include cases we've not seen.
We want to include those. So
All right, the motion is to accept council's recommendation, offer revocation, and in the meantime, flag both the firm and the individual's license.
Did you read, were the numbers read? They were
Yeah.
read, weren't they? Yes.
We read those
A while
in.
back, yeah.
Well, not for the 2 new cases.
Mhm.
We ain't got those.
Ms.
We're-
Kind of
we
don't matter.
accept council's recommendation. We hadn't even seen it.
I think that could.
I think we just
bite
handle
us.
this right here.
I
and
think
then-
that could come back to bite us.
Yeah.
You weren't even willing to listen to the two cases presented.
So, regarding those two additional cases, same respondent,
Same respondent.
they'll show up sometime in the future. Is that correct?
Yes.
Okay.
We've already discussed this before. I don't think it would be an issue. But if you'd like to defer it until next month, we can do that. But the summary will be extremely similar.
I just think that this is such a revocation is so severe that we may be amiss by saying just whatever else comes up from this person. I don't want that to come back and bite us either. So I would rather it be presented to us, and we'll just say, this was that case from in February.
I think we're going to address these in front of us.
Yes.
But the other two that are coming down the line, we're going to wait and let
Wait.
them come down the line.
Right,
Okay?
please.
Yeah.
That seems to be the sentiment of the board or the commission at this point. You've heard the motion. Is there further discussion? All right, if this motion passes, council is going to go to the licensee and say, will you voluntarily allow your license to be revoked? In the meantime, Real Estate Commission staff is going to flag this license, so in case that person or license shows back up, it'll be brought to everybody's attention. That's how I've got this motion. Everybody with it?
Yes.
All right, let's vote on the motion. If you're in favor of that, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Now,
So do we have to do this on that? Oh, okay.
all right, so that concludes the legal reports. Ms. Matlock has a rules update for the record you'd like to tell us about.
Yes, just generally, I wanted to give you an update about the fee rules. Those rules are still moving through the channel, but I would like you to be aware. Governor Lee signed an executive order in January, so all rules have a 90-day. There's a 90-day stay. So that doesn't mean that the rules can't still go through Attorney General pre-review or Governor pre-review. It just means that all rules and regulations cannot be filed with the Secretary of State for 90 days. And our rules were not already filed by that point, so we are under that stay. But once we're allowed to file it with the Secretary of State, we'll go forward with that.
Is that kind of a normal thing that governors do, or did they have some concern with us? Or?
No, it's not. It's not just us.
Okay.
It's for all of the
Okay.
executive branch departments. So it's a new. It usually happens within transitions.
All right.
And that 90-day clock started.
I want to say it was like in the first or second week of January, so a couple weeks into it.
Else from legal. Thank you all. I know we've kept you here again through lunch, but we've kept us here too, so I don't feel too bad. All right, Ross, we got a little catching up to do with you. Thank you all. You can speak there, Ross. Others have. Yeah, it's a position of power.
Thank you, Mr. Chairman, members of the commission. In the interim from this morning, I spoke with both individuals. I think I can clear everything up.
Okay, perfect. You want to start with the
Ms.
lady from
Feynman?
Knoxville?
Yes. It's all my doings, I'll have to say. In the document that gives you the biography, I conflated what I had read about her with some things on their website to think that she had 15 years of experience. She has 10. And she is a very gracious lady. I had spoken with her about, she's got the background in Virginia. She started in 2009. She then went to Georgia in 2010 and then back to Virginia. And she's always been an affiliate broker. She's never been a broker. And then in Tennessee, she became licensed 2018. Her and her husband have a business which again, is on the website there, and they're involved in business consulting and speaking, and they also have the Century 21 advertised, at least at the bottom of that, and then on the left-hand side it's got her name. So she was very forthcoming with all of this, and she had actually tuned into the meeting this morning and understood that there was a concern, and she's just totally flabbergasted about it, wants to clear it up, just wants to be clear that she's in her 10th year as a licensed real estate agent, and anyway, she doesn't want anything other than to move forward in a professional way, and she wants to follow the rules.
Well, after your conversation with her, do you feel better than ever recommending her for approval?
Absolutely. Absolutely. Thank you, Mr. Chairman.
For motion.
Move to approve.
Let's just for the record identify her by name, Ross.
Laura Fangman.
Okay.
Move to approve Laura Fangman as a instructor.
Second by Mr. Diaz. Discussion. Those in favor of that?
My question, the mission team, so is that a different business? Is that her consulting business?
It appears to be that is what they have grouped together as a sort of an and-all business, that they do business consulting, speaking, community events, and so forth. But then also they do real estate business. So she has correctly, at least on the surface of that website, it explains that it's Century 21, but she's not leaving that out at all.
When she sent it in to you, did she say she was a Century 21?
Yes.
Okay.
Yes, and I confirmed that with a resume and so forth. And it's my error about the 15 years. Should have been 10 years.
I'm sorry.
One other question. So it's a team. So there's more than one person.
Her and her husband.
But she's the only one applying to be instructing.
Correct.
Okay.
She's already an agent.
He's a licensee or not a licensee, or we don't know. We don't care.
I think he was, because when I looked it up, he was on the Century 21. It had Century 21 on it.
Okay.
I was just looking at Ms. Fangman.
Okay.
Other questions? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Thank you, Mr. Chairman, members of the Commission. The second one was an individual also I spoke with, Mr. Eldon Holliday, Jr. In the documents and on the biography, he had not, I guess, fleshed out his resume to the extent that now I understand there's a little more to it, that he has been home inspector in Tennessee since 2007. What I had on file was his renewed license, which was 2017. He's been a home inspector in Mississippi since 2007 as well. He lives in Olive Branch, which is just outside of Memphis, so he considers himself, Mississippi as far as his residence, but actually his business is in both Tennessee and Mississippi.
Motion to approve Eldon Holliday, Jr.
Motion by Ms. Hill, seconded by Mr. Wood, that this applicant be approved to instruct in Tennessee. Mr. Holliday. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you
Mr.
for looking
Chairman.
into that for us.
Thank
All right,
you very
under
much.
commission discussion, we've got a little discussion here, a report on Arello. First of all, did you get reimbursed for your expenses?
You should have.
I haven't looked in my bank account, but Aaron actually contacted me about it, and he was taking care of that for me. I haven't really looked in my bank
let me
account.
know?
I'll let you know.
Thank you.
I
All
know
right,
that was in the works, though.
I know the expense report on our end has been approved, so.
Okay.
All right, let's hear your report.
Okay, so I went Tuesday, January 8th through Thursday, January 10th, to the Arello Leadership Symposium. That consisted of the executive committee, the board of directors, of which I'm on, and I represent District 2, committee chairs, and I'm a committee chair for the program committee, and the co-chairs. Altogether are maybe 40 or 50 people. We were at the El Conquistador Hotel in Tucson, Arizona. On Tuesday, the program committee, we met and did a lot of work on our upcoming meeting, our mid-year meeting in Salt Lake City, Utah. It has been our responsibility to get keynote speakers so I've communicated with the executive director of the Utah Real Estate Commission and the president of the Utah Real Estate Association. So we've got a really great speaker, Kenny Parcell. Kenny is our keynote speaker. He's a vice president at NAR, well known throughout the United States. He's going to be speaking on the rapidly changing landscape of real estate. So also under my purview, the program committee has to schedule meetings. That's why I knew when the meetings were taking place as far as the education director. All the events, member receptions, opening receptions, conference room locations, AV requirements, just all those details. And so that's what I did on Tuesday. On Wednesday, we all gathered together. Before I went, they sent us Myers-Briggs personality indicator tests. I don't know if you all have done those. My personality has not changed since I did it 10 years ago. That was mainly to help us to understand. I always thought that personality traits were so I could understand other people. But this speaker helped us to understand ourselves and how we could better speak to other people and communicating, making decisions, managing change, and managing conflict. So y'all know what my personality. I'm not going to go over those things. But we also that day went over the strategic plan, and the strategic plan will be working. We have it till 2020, and most of that is completed. So we're fixing to start working on the strategic plan for the next 4 years. And then Thursday was our board of directors meeting. I'll let you know that we're having a meeting. I know Bobby was at the last one. If you go to NAR mid-year meeting, we're again meeting with NAR to talk about risk management and professional standards. So if you're in Washington for that, I hope you'll come. The annual meeting in 2020 will be in Orlando, and the annual meeting in 2021 will be in San Antonio. I would encourage you to take the time to look at the website, and you should each be receiving Boundaries newsletter, and look at that and see what's happening with that. The annual meeting is September 17th through the 21st, and that's in Denver at the Grand Hyatt Denver. And so now we're working on all the details for keynote speakers and receptions and all that kind of thing for the Denver meeting. So that was basically what I did.
So did you learn anything about yourself?
It was just reaffirmed.
Oh, you're already pretty.
I have some things to work on.
Thanks for taking 3 days out of your life to represent us at that meeting.
That's right.
Next up on the agenda is a discussion of the Salt Lake City meeting in April. And I think we need to know who's going. Staff-wise, you two ladies, correct? I can't hear you.
I would like to get that just approved on the record of who's going to go.
Oh, we'll do that. I just want to make sure.
And I'll tell you that we need to have the room deadline by March 15th.
Yes.
We missed that deadline last time, and it ended up she didn't get to stay in the hotel with us. So March 15th, we've got to have our rooms by then.
Yes, that's why
It goes to our
even though I know everybody's tired, I would like if we could go ahead and discuss this and vote because our next meeting is a little too close to that deadline. So, the whole list of order with commissioners has kind of gotten all out of whack. But in our time, I know Fontaine was able to attend the last mid-year, and then Rick was able to attend the last annual. So,
we'll entertain a motion that includes you two and Ross, if we can pull that off, because we discussed that earlier.
There's a good chance, I just wanted to say, it states April 10th through 13th, but there's a good chance that from a travel standpoint, it'll be April 9th through 13th because of the district meeting that's taking place on Wednesday. So as far as commissioner's schedule, it's more accurate to maybe say April 9th through 13th.
Since Marcia is on the board, shouldn't she take one of the positions?
That's a very defensible position.
Or, yes,
But-
and then have one other person?
I'll tell you this. I liked it when we had an order where we could go down the order. You know, say it's Bobby's turn, it's your turn. Because I'm going to go whether in my opinion, I would rather pay my way and two other people have the opportunity to go than to always take up one of the slots. I don't want to, if somebody wants to go. Now, you may not, any of you want to go, I don't know, but I would encourage you to go.
Let's just.
Who has an interest, maybe?
I can't go. I got a conflict.
And it's where?
April
It's
9th
in
through 13th.
Salt Lake City, Utah.
One week into a new hip at that point, so I'm not going.
Oh, yeah.
Jeff? Okay. Diane, by
Ken, or
default.
you can't?
I thought Rick was interested.
Rick
He
went last.
did just go to the last, he just went to the annual.
You're about to, if
We
you'd
don't
like to
have
go.
anybody, we don't have this person in Austin's,
Probably shouldn't say.
Marcia
Yeah.
and, or, whatever.
But if you absolutely can't go,
No,
I don't want anybody to feel pressured about it either.
As soon as we get back. It's just back to back.
So the chair to entertain a motion that included Marcia, Anna, Caitlin, Ross, and Diane.
Yeah, you can go.
Well, that's the motion on the floor. I saw Mr. Diaz make that motion. So the second was by Ms. Taylor. No, I'm sorry. I heard you, but she beat you
Okay, that's
slightly. Okay. So that's the motion on the floor at this point. You got it?
Is there anybody that if Diane gets back and says she can't go, Fontaine, you cannot go?
I don't think I can go at that point in time. Thank you.
Let me
It's worth going.
check calendars because my
Okay.
calendar is not the only one
And
under
I'll
consideration.
I understand.
default to you. Yeah.
All right, the motion's on the floor. Let's vote on it. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, Caitlin, what have we missed?
Nothing. I just wanted to say a quick thank you to Mr. Smith. He's now taken over the meeting responsibilities probably for, I don't want to guess the number of months, but each month it seems to get a little easier and makes my job a little easier. So
Who is
just
Mr. Smith?
Aaron Smith.
Oh, Aaron.
It is a generic last name.
He's not a generic guy. He's
No,
a one-of-a-kind
he's
guy.
There's nothing generic about that
And we all
fellow.
want to thank him for doing the great job that he's doing too.
Yes.
All right, let's see.
Goes over and
Thank you,
above.
Aaron.
Let's see if there are any closing remarks here. Fontaine, anything you'd like to say?
No, I don't think so. I
Beth,
thought there was something else.
I was giving you time. but-
Did we talk about going to Germantown and?
Oh, that's right. That's what you want to talk about.
In May?
Tell us
In
what
May.
you tell us what
We're
you've
going
done.
to the Germantown City, our meeting's going to be at the Germantown City Hall in May, and I've forgotten the dates now. And it's also the bicentennial of Memphis and Memphis of May at the same, and the month of May.
It's May 9th and 10th.
All right, and then
And can we go to my favorite restaurant?
Well,
Oh,
Mar
yeah.
is going to take us to dinner on the,
Night?
it's
Wednesday
Wednesday
night.
we get there, with the Wednesday night. So, and I don't know how long the meeting is from there, but
Folks.
Folly.
Folks Folly, but no, Mar's not going to take us. to Folks Folly. I already know the answer to that.
Yeah, okay.
But we'll go.
But I have asked
we'll
her to go ahead and get the hotel arranged so we'll know kind of where we are. Germantown itself doesn't have a lot of hotels right there. It'll, yeah.
So get them closer to Memphis then.
Well, there are a lot along Poplar, but they might not be the right ones, you see.
Anything else, Fontaine?
No, thank you, John.
My
I
pleasure.
appreciate your meeting and
You're
leading.
welcome.
You did a beautiful job.
Oh, yeah, thank you very much. Jeff, any comments?
No, sir.
So you're 3 hours up this morning, 3 hours back this afternoon. You'll be okay, right?
I'll be okay.
You can handle it, okay.
I'll be okay.
Diane?
I just want to say I appreciate each of you that were able to talk and discuss and sound out, and I just really do appreciate everyone here. And just a reminder to keep a past commissioner and his family in your prayers.
Thank you. Bobby?
Kind of piggybacking on what Diane said, I think I get more and more impressed with the function of our staff first. And that's the things that they get done and have to do this on a monthly basis. But probably that's second to I was I guess awed by this person when I first got on the commission and still today. John Grease is probably the best chairperson I've ever been on a committee with, and can flat move a meeting along. And he's taken the meetings which could take 2 or 3 days and move these things along. So someday when I grow up, I want to be Commissioner Grease.
Just like John.
I want to be just like John.
Mr. Grease.
Here's what I think. If we had 9 people on this commission today, we'd be here at least another hour. I don't think it has anything to do with the chair. I think it has to do with the membership.
If we'd have gotten that 6th lawyer, we would have been here for another hour.
All right, Marcia.
I agree with everything everybody said. I want us to keep Grover Collins, a former commissioner, his family in our thoughts and prayers. His daughter Leanne's very sick, and we want to all be praying for her. And then I also want to mention our brother Johnny Horn, who's not with us anymore on this commission, how much we're going to miss him and all that he did. He was kind of the conscience of this group. So we're going to miss him.
Thank you. Just a couple comments. Fontaine really has worked a lot harder, and she's led on about getting this meeting put together in May, and I appreciate that effort. I know it's not easy. Diane went through it. Many of us have at one point or another, and getting the details ironed out is great. Second of all, we've got an October meeting in East Tennessee, and you all need to be thinking about that. Gatlinburg has made an offer to host us. There may be other places, but we need to maybe next month decide on that.
That would be in October?
Yeah.
If you're going to Gatlinburg in October, you need to be starting getting rooms or something.
Well, I'm not disagreeing with any of that. Parking spaces.
Yeah,
But-
that's the. You can't pick a busier time.
An hour to drive through town.
Don't be there on the weekend.
I'll get a cabin.
Yeah, we could. I bid not to cook and clean.
I'm not going
Videos in the cabins are what we're looking for.
We get a VLS licensee.
So my final statement, back to Bobby's point about staff. This is a busy time for the staff of the Tennessee Real Estate Commission. We've had 32,000 licensees have to come up with errors, submissions, insurance. That doesn't count any other topic at all. And sometimes people get frustrated trying to get in touch with staff of the Tennessee Real Estate Commission because they want, like most real estate agents, instant answers. By God, if I call, I want you to answer the phone and tell me what I want to know and tell me what I want to know.
Yeah.
So, as commissioners, if you occasionally get a call from some disgruntled licensee or public member, I think the best way to approach it is to get what information you can, then get it to Caitlin by email or by phone, and not necessarily just give that person a phone number or an email address. So that my experience, at least with Caitlin, has been if you'll give her that information, she'll research it and make the call back to the licensee and get that person satisfied in most cases. Not always. Sometimes you can't please anybody, ever. But you did a great job, Caitlin. Your staff's doing a great job. Legal, I like legal.
We need legal.
In the past, I haven't always liked legal, but I mean, you guys are great. As long as you can take a little bit of gentle harassment every once in a while, we'll all be okay. Sure.
The lawyers always get beat on, don't they?
On the trick pay, I mean, if somebody, is there
I looked this week.
Frequently asked questions.
Well, I looked because I had 4 phone calls from one person that has tried to get through the check. I didn't bring all that up, but anyway. So as I got to a computer out of my car on the last one, because I suggested that they go on site. And I thought, why can't this person figure this out? And I went on site. There was something that didn't quite match then when I went to the code. And the question was, I forget what I put in, but it was they had their license at one time back in early 2000s. It's expired. Now there's confusion about what they take over to the classes and then retesting and all that. For me to go to this, it was clear to me, and I said, in my opinion, this is what, but it didn't quite match what the website was saying.
Yeah.
Frequently asked questions, or I didn't think
there's
it quite
definitely
matched.
room for the website to be clearer.
Yeah. So that was the only thing I just happened to look myself this week for that reason.
Anything else? Were you looking for an answer to that?
Oh, I found the answer in this.
I mean, did you want a response?
No.
Okay, just checking.
And now Fontaine had the question.
No,
Were you-
Fontaine
did you have-
can't get on the website, so forget me.
All right, if we're done, we're done. Stay
Motion to adjourn.
healthy.
Thank you.
Okay.
Thank you.
Stay healthy.
Yes.
Safe travels, everyone.
Don't even get on there.
Well,
Everybody remember.